Here for the sitting. Please sit down so that we can start. Yes. Can you tell those outside that if they are coming, they should really need to come inside so that we don't have to? Nobody's coming. Nobody's coming. Please, I don't know why. I don't know whether it's still want to help you because they are supposed to be contacting the. No, just leave it outside there. Good evening, everyone. Please let's settle down and be ready for the. Yes, please. I hope that the noise would reduce so that there will be no impedance with respect to the adjudication of the case. So please try your possible best to be quiet so that we can proceed. All right. Is the petitioner around? Counsel for the petitioners. Don't you have a microphone?
My lords, may it please this honorable court, I am Ebenezer Ni Kwate Kwati, the Legal Affairs Commissioner of the SRC. And today, I appear before you as the first counsel for the petitioner, acting under the express authority of Article 66,
You should just be giving your name.
G. Rate me as my co-counsel.
Per Mauto Ami Avemi, member of the Legal Affairs Committee.
The first respondent.
Respectfully, my lords, Anochiwa Anochi Abnadokas, lead counsel for the first respondent, appearing with
Godwin Agyei. And Abigail Sewa Bempa, co-counsels for the respondent.
Is there? I don't know who you are. Like, did you introduce yourself?
Respectfully, my lords, Jacqueline Sapon, respondent for the second, representative for the second council.
All right. Counsel for the petitioner. Please, let's hear your submission.
Respectfully, my lords, permit me to raise a preliminary objection. Respectfully, our preliminary objection is to contend the capacity of the Legal Affairs Commission of the SRC to be the representative for the petitioner on the following grounds. The Legal Affairs Commissioner has a constitutional duty to defend the Executive Council. My lords, Article 31(3) of the SRC Constitution 2021 as amended provides that the Legal Affairs Commissioner shall be the Chief Legal Counsel of the Executive Council. Also, the Legal Affairs Commissioner under Article 31(4) shall represent the Executive Council at all Judicial Committee hearings under the SRC. My lord, the respondent, second respondent for that matter, as a legal commissioner, is a member of the Executive Council pursuant to Article 19(1)(I) of the SRC Constitution. Article 22(12)(a) XII states that the president shall appoint persons to occupy the head of the following offices, which the Electoral Commission is also part. By purporting to represent the petitioner in an action against the Electoral Commission, my lords, it's frivolous because it violates Article 31(3) and 31(4) of the SRC Constitution, which mandate him to be of legal duty to the Electoral Commissioner, my lords. Therefore, we pray that this court sustain this preliminary objection and bar the Legal Affairs Commissioner from representing the petitioner in these proceedings. The petitioner, if desirous of pursuing this matter, should be directed to obtain an independent legal representation in accordance with fair hearing standards. Respectfully submitted.
Thank you. Counsel for the petitioner.
Respectfully, my lords, if this court would go ahead with the preliminary objection, we would appeal to this court we would move a motion. We file a motion for this honorable panel to recuse a member of the panel.
We need a response to the submission the counsel.
Very well.
My lord, the first respondent objects my capacity to bring action on behalf of the petitioner, citing lack of standing. The objection is misconceived and must be dismissed. Pursuant to Article 66, Clause 2, Paragraph G of the SRC Constitution 2021 as amended, is to the effect that the Legal Affairs Commissioner...
Relax. We are also going through so that you should also relax for us so that we can find the provisions you are talking
Article 66, Clause 2,
yes,
Paragraph G
yes.
of the SRC Constitution expressly states that the Legal Affairs Commissioner may represent any student who is a party in a case before the Judicial Committee, except in cases involving Executive Council. My lords, this present case does not involve an Executive Council. It involves a private student, that is the petitioner, a candidate in the election, the first respondent, then the Electoral Commissioner, an independent body under the SRC. My lords, Article 10 of the SRC Constitution 2021 as amended guarantees the independence of the Electoral Commissioner. And again, in the case of the Legal Affairs Commission versus the Union of Non-Residential Constituency and Electoral Commission, where the respondent in that case, the first respondent in that case, raised the issue on capacity, that the matter also affected the Electoral Commission, who they said was an executive at the time. This honorable court interpreted further to affirm that where the Judicial Committee upheld the capacity of the Legal Affairs Commission to initiate and represent action, the committee held that the Legal Affairs Commission bears the constitutional responsibility of safeguarding the conformity of all constitutions and governing documents of student bodies with the SRC Constitution. It's logical to follow that in discharging this constitutional mandate, the Legal Affairs Commission has the inherent right to enforce the provision of the SRC Constitution. This honorable court went on to state that the Legal Affairs Commission is composed of students, and as such, its members individually falls within the category of any students contemplated under Article 3, Clause 1 of the SRC Constitution 2021 as amended. Furthermore, the court concluded that the petitioner possessed the petitioner at the time, the Legal Affairs Commissioner, possesses the prerequisite capacity to institute this action, and the preliminary objection that was raised by the respondent then was dismissed. Therefore, my representation in this present case is valid, lawful, and constitutional. I respectfully urge this honorable court to dismiss the preliminary objection and proceed with the merits of the case. Humbly submitted, my lords.
You should be giving us some time. Yes. 19.
This is a fine. Yes, so after mentioning some of the appointees under the Executive Council, it goes ahead to mention that and all other appointees of the President, with the exception of the Judicial Council. So from this, you can know that the only body which is not part of the Executive Council is the Judiciary and the Speaker of Parliament. And by the doctrine of separation of powers, we understand this, that they are independent bodies. However, with this constitution, though the independence of the Electoral Commission is guaranteed, they still fall under the Executive Council. And by virtue of Article 66 of the SRC Constitution, I think, Jane specifically, you will notice that the Legal Affairs Commissioner cannot take a claim which has the claim of a student, which has an Executive Council member as part of it. From this issue from the matter before this court, you know that the EC, the Electoral Commission, is actually part of the Executive Council. And by virtue of that, the petitioner, who is being represented by the Legal Affairs Commissioner, lacks the local standing to come before this court and make the EC as a party to this suit. For this reason, we submit that you strike out this petition. Humbly submitted. My lords, with the preliminary objection. No. Yes.
Another preliminary objection.
It's not properly. This is sure.
Yes, let's resolve is it linked to?
Yes.
Would it affect our decision, or would our decision affect that?
Yes.
Okay.
All right. So, as I already stated, that from 66, they are supposed to represent every SRC appointee or officer. But they have willfully neglected this constitutional duty by taking the claim of a petitioner. And for that reason, we pray this court.
I didn't hear what you said.
I said that they have willfully neglected their constitutional duty. The legal affairs
Which constitutional duty have they?
to represent SRC officers in any dispute before this court. And for that reason, we prayed this court that they allow the petitioner to bear the cost for any expenses they will incur.
To pay you.
Yes.
And you want money
No,
from
not necessarily that. But any expenses they will incur in procuring a legal representative because of their breach of their constitutional duty. Yes, that's what we want to add to it.
My lord, with the leave of the court, permit me to respond to the second respondent's objection. My lord, Article 19, Clause 1 of the SRC Constitution 2021 as amended lists the Executive Council members, and as such does not include the Electoral Commissioner. The phrase, all other appointees, as referred therein, refers to additional Executive Council members, staff like Presidential Advisor and more, and not independent bodies like the EC. Article 10 of the SRC Constitution 2021 as amended guarantees the independence of the Electoral Commission, and it's not subject to...
Is the EC an appointee? Have you subjected your mind to Article 19(1)L? It says that in all other appointees of the President, with the exception of the Judicial Council, because if it has listed it, why do you think that it's... What do you think would be the intention of the Freemans? Why would they add that provision to it?
My lord, I believe... My lord, it is reasonable to believe that the framers of the Constitution expressly stated that it includes all appointees of the President except the Speaker and the Judicial Chairperson by reason...
Is she an appointee? Was she appointed by the President?
Yes, my lord.
So what are your reasons? Why do you think that this provision should not apply to her?
To guarantee their independence established under Article 10 of the Constitution.
So you are saying that if they are part of the Executive Council, they are not independent?
Not properly so called.
Then what are you saying? Help us. If they are not part of the Executive Council, does it mean they are, they are independent? And if they are part of the Executive Council, does it mean that they are dependent?
My lord, the Executive Council is headed by the President, and therefore, if they are part of the Executive Council, then automatically they are subject to the control and directions of the President. And Article 10 of the Constitution prohibits that. By this, it is reasonable to say they are not part of the Executive Council.
My lord, I think Council is not abreast with the fact that the Electoral Commissioner has administrative duties. And in such, the Constitution has provided independence in the administrative duties. This is a court. In Ghana here, when the Electoral Commissioner is being... It's organizing the elections and all that. So I'm trying to make a case that if they have been sued in a court it is the duty of the Legal Affairs Commissioner to represent them. My Lord, let's take a practical example of Ghana's procedure. When Electoral Commission of Ghana is being sued, it is being sued together with the Attorney General for them to represent that state agency. It's not Attorney General suing in favor of any petitioner. That has not been the trend. And it is nowhere in our laws, it's nowhere in Ghana, and even at this place, KNUST.
Counsel, I believe you are mistaken. Does the Attorney General never sue the Electoral Commissioner? The Electoral Commissioner as an independent institution?
I'm talking of the fact that here he is supposed to represent the Electoral Commissioner in this case. The Electoral Commissioner is an SRC officer. He is part, or she is part of the Executive Council. She's part to the SRC Council. And as such, the Constitution has mandated the Legal Affairs Commissioner to represent them. So here in this case, he is coming under the capacity of a Legal Affairs Commissioner with a petitioner, any student. So we plead with this honorable court that the petitioner should be allowed to take a legal representative, any other legal representative, aside the legal affairs, because the legal affairs has a constitutional duty to perform. Yeah, so the legal affairs in this case would have to even enter defense for the Electoral Commissioner, which has not been done. That would be a conflict of interest in that regard. Thank you.
So, Counsel, one last question. Are you saying that in case that the Legal Affairs Commissioner, are you saying that in case you find out, the Legal Affairs Commissioner finds out that maybe the EC is doing something which is inconsistent with the Constitution, he has a duty to defend her? Because as far as I'm concerned, if you are able to, if you read the statement of claim from the petitioner, he said he gave her an advice and that she neglected that advice. So even after advising her, you are saying that he should come and still defend her? Or you are saying that he shouldn't sue her? What are you saying?
So our claim is that by virtue of the Constitution itself, it makes the Electoral Commission part of the Executive Council. We are not contesting the fact that the LA can give advice or can sue the EC when they breach their constitutional duty. However, in this instance, by the Constitution itself, the Legal Affairs Commissioner must not accept any claim from a student when an Executive Council member is a party to that dispute or that claim. And that's our contention, not about even the legal advice. Yeah, so that's it.
So, Counsel, you're saying that you agree that the Legal Affairs Commissioner can sue to enforce the SRC Constitution?
Yes, they can.
My lords, however,
Your Lordships.
Yes, let's hear.
Respectfully, Your Lordships. The EC is an independent body, separate from the executive, the legislature, and the judiciary.
Are you attempting to repeat what you have already said?
No, Your Lordship. Responding to what they said, that the Electoral Commission is part of the Executive Council, and we do not accept that. Right. Your Lordships, the EC is an independent body, and it's separate from the executive, the legislature, and the judiciary. And the function of the EC is different from that of the executive. And we would all attest to the fact that many bodies are appointed by the president, who is the head of the executive. But that does not make them part of the executive council. An example is judges. Judges are appointed by the president, but that does not necessarily make them part of the executive council. They fall under the judiciary. Now, the act of a judge appointing a person is merely administrative, and the act of the president appointing a person is merely administrative and does not automatically confer executive membership on such a person. Your Lordship, since the Constitution did not expressly state the Electoral Commission as part of the Executive Council under Article 19, even though they are appointed by the President, we cannot infer such membership on the Executive Council. That is what makes them an independent body. Because if they were to be construed as part of the Executive Council, Your Lordship, that would defeat the purpose of the independence of the EC and Article 10 of the Constitution, the SRC Constitution, amended in 2021.
Okay, fair your submission.
My Lords, please, I would like to object to this. And I think that in as much as I want to agree with what she's saying, because that's what we have in our current constitution, not this constitution, which is the SRC Constitution. I
didn't hear what you just said.
I said that in as much as I would like to agree with what she's saying, because that's what we have in the Constitution of Ghana, where the Electoral Commission is seen as independent. However, with our current constitution, which is the SRC Constitution, it has fused the Electoral Commission with the Executive Council. And by virtue of that, and not implying from something which is not in the Constitution, we want this court to strike out their petition because they lack the legal capacity to bring this claim on behalf of a petitioner in an issue the EC is a party to.
My Lords.
Thank you.
Sorry, my lord.
Please resume your seat.
They know.
Having heard both parties.
My lord, respectfully, for the purposes of education, I would like to refute what my opponent said because she misled the court and everybody that is watching to say that the Electoral Commissioner does not fall under the Executive Council, unless, of course, she wants to infer or make some type of interpretation that we don't understand.
Also,
Yes.
we have heard your arguments, and it is the duty of this court to interpret whether we have been misled or not.
All right.
So kindly resume your seat.
All right.
Yes, so having heard having heard the arguments from both sides, we have a ruling on the matter at hand. And counsel for the petitioner is very pertinent that you make a very good juxtaposition between this present case and the case between the Legal Affairs Commissioner and UNRC. So that is the legal affairs, that case involved the Legal Affairs Commissioner suing the EC. But this case involves a party who is in a case before the Judicial Committee. And that party has sued, not the Legal Affairs Commissioner. So in this case, the duty of the Legal Affairs Commissioner here is representing that party. However, our Constitution expressly says that you are eligible to represent any student in a party in a case before the Judicial Committee, except in cases involving the Executive Council. And Article 19 of our Constitution says that the Executive Council, the EC is part of the Executive Council. Article 91L, which says that and all other appointees of the President, with the exception of the Judicial Council chairperson, the Speaker of Parliament, and their appointees. So we believe that the EC is a part of the Executive Council, else we'll not be able to put, we cannot say the EC is not an SRC officer. And according to our Constitution, an SRC officer is a person who is part of either of these three working bodies, either the Executive Council, the Parliamentary Council, and the Judicial Council. So why are you saying that, where should we put the EC? And of course, Article 19L, and purposively from the intention of the framers, you can see that they wanted to include the EC they wanted to add the EC to the Executive Council. Notwithstanding, the EC is independent with respect to performance of its administrative functions, right? So we deem that it's not new to our Ghanaian jurisprudence that a party can be struck out from a case. And that takes authority from the Civil Procedure Rules to CI 47. And so we are suing we are striking out the party, the EC, out of the case and just involve Francis Kusi and Nana Agyei-Gyebi as the respondents of the case.
Well noted, my lords. Much grateful.
So yes, submissions from the petitioner. there?
Opening statement.
Yes. Give us your opening statement.
Hello, Council. So, if we are,
Please, yeah, I want to. Yes, as I said, I know that it has been struck out, but then.
so if we are moving into our opening statements, it means that we are done with the preliminary objections. If we are moving into our opening statements, so are you paying attention? If we are moving into our opening statements, it means that we are done with our preliminary objections. Is that so, Council?
Yes, my lord. My lords, this petition challenges the eligibility of the first respondent, Nana Agyei-Gyebi, vice presidential candidates in the ongoing SRC election, and further questions the conduct of the second respondent who has been taken off for that purpose. I also take him off our statements of claim. At the heart of this petition lies a simple but yet fundamental issue on whether or not a candidate who fails to resign from office pursuant to the provision in Article 96, Clause 1 of the SRC Constitution 2021 as amended can be validly allowed to contest for the higher office. We will establish that the first respondent remained a member of the 16th Parliament, SRC Parliament, at the time of his nomination, and that no proper resignation was submitted in accordance with the constitutional procedure. This case is not merely about its technicalities, my lords. It is about upholding the principle of rule of law, protecting the integrity of the SRC election, and also to affirm the supremacy of the SRC Constitution that no person is above the law. We respectfully invite the Honorable Courts of competent jurisdiction to enforce the Constitution without fear and favor, and to grant the appropriate relief in the interest of justice, student democracy, and institutional accountability. Humbly submitted, my lords. On the first issue as to whether the petitioner humbly submits that as to the violation of the resignation requirements of Article 96, Clause 1 of the SRC Constitution 2021 as amended by the first respondent, Nana Agyei-Gyebi, will amount to his disqualification and affect the entire ticket. My lords, on the first issue, the petitioner submits that the first respondent's candidacy is constitutionally invalid because he failed to resign as a member of parliament before filing his nomination, which is a clear violation of Article 96, Clause 1 of the SRC Constitution. With the leave of the court, permit me to read Article 96, Clause 1 of the SRC Constitution. Article 96, Clause 1 of the SRC Constitution. Any SRC officer shall communicate his resignation in writing to his respective head of council under the SRC 7 days before the date of resignation and copy the same to the Dean of Students. The law is not ambiguous on this, as it says an SRC officer must submit his resignation to the head of council, and in this case, the Speaker of Parliament, and copy the same to the Dean of Students. Here, the first respondent resigned only as course president, but remained a member of Parliament, a fact he does not dispute. No resignation letter was submitted to the Speaker, nor was same copied to the Dean of Students, or any notice of his resignation as a member of Parliament, as with the leave of the court permits us to show Exhibit A. My Lord, may we?
All right, yes, permission granted. Do the respondents, do they have a copy? Do you have a copy of exhibits? Exhibits what? A?
Exhibit A.
Yes, do you have a copy?
We don't have, respectively, we don't have a hard copy, but then they sent it
I
to
said
us.
copy.
Hard or soft?
Copy, there are two types of copy.
So I said we don't have hard copy, but we have soft copy.
It's a copy.
Exactly.
So you have a copy?
Yeah.
Okay. Proceed.
So Exhibit A is Exhibit A is a petition filed by the Speaker of the 16th SRC Parliament to the Dean of Students to acknowledge that he hasn't received the resignation letter of Master Agyei-Gyebi as a member of Parliament. My Lords, Article 46, Clause 1 of the SRC Constitution.
Council, can you give us a minute? All right, Council. Yes, Council, please hear you.
So, my Lords, Article 46(1) talks of the mode of becoming a member of the SRC Parliament, aside being there by virtue of the constituency you represent, as it talks of the oath of allegiance and the oath of member of parliamentary council set in the third schedule of the Constitution. So if that is so, to resign as a member of Parliament, one must comply with Article 96, Clause 1 of the SRC Constitution. As Exhibit A shows, the Speaker admits in a petition to the Dean of Students that the first respondent, or the respondent in this case, refused to submit to him, the head of the Parliamentary Council, his resignation as a member of Parliament. And, my Lord, that is where we are basing our argument to say that he never resigned as a member of the 16th Parliament when there was a public notice of his resignation as course president published by his judicial chairperson. My Lord, the disqualification of the first respondent, if granted, necessarily invalidates the entire presidential ticket based on 3 reasons. The joint ticket principle. Under the SRC, the presidential and vice presidential candidates are not separate entities. They run as one. So if the vice president is disqualified, the presidential candidate cannot proceed alone because the dole is legally recognized as one candidate for electoral purposes, such as even the display of the candidates on the ballot screen on the day of election. Again, my Lord, this honorable court has already ruled that the running mate's disqualification voids the presidency candidates. My Lord, in my diligent search for the full citation of the Eduba Charles case, my Lord, we came across social media posts at the time and also display of vetting results at the time of Eduba Charles case in 2008, in which, my Lord, we will display on the screen very soon.
Relax. Did you send those, what you are talking about, the vetting results, did you send them to my registrar, or did you send them to the...
My Lord, in my diligence...
No, did you? Yes.
My Lord, I chanced on those media pictures this morning, and I sent it to the mode, my Lord, you asked us to display the exhibition. We sent it to the number you gave us to send our exhibits to, my Lord.
They are not the respondents. Like, don't you understand? I'm trying to say that the respondents should have been aware of any evidence you are trying to tender.
My Lord, notwithstanding that, the Latin maxim, ex nihilo nihil fit. You cannot build something on nothing. If the vice presidential nomination is void, as we've proven, then the presidential candidate's tickets collapse with it.
No, we were talking about the evidences. So it means that you are not tendering it?
On the Eduba Charles case, I'm not. Yes,
okay.
Yes, please.
Proceed.
Humbly submitted, my Lord.
All right, counsels for the respondents. Do you have anything to say?
My Lordships, we object to the evidence because we didn't have the evidence.
Yes, we have.
Thank you.
Yes. So, yes, give us your opening statement or your submissions.
Respectfully, my Lord, permit me to give my opening case. Today, this court has been summoned by the plaintiff, represented by the Legal Affairs Commissioner, on malicious and political grounds to determine the validity or otherwise of the second and first respondents. The petitioner, knowing very well that this petition is frivolous and ill-spirited, nonetheless has got the audacity to summon this honorable court and using this court to pull his dirty trick. Failing to perform his constitutional duty, reference to the Legal Affairs Commissioner, he is also stretching his neck like that of an octopus.
Is that your opening statement, or you are making your submissions?
Yes. Sorry, we are just servants of the law, and we are here to enforce the spirit of the law. We pray that this court, at the end of the day, will hold the candidacy of Mr. Agyei-Gyebi to be very valid. Thank you. Starting with my submission, my Lord. The respondent submits that there has been substantial compliance with Article 96(1) of the SRC Constitution. The respondent does not dispute the constitutional obligation to resign prior to contesting for another office under the SRC. My Lord, Article 82 of the court's constitution provides the manner in which the president of the college should resign. And here we tender in Exhibits 1, 2, and 3. Exhibit 1, which is...
You have a copy for us?
Yeah.
Yes, we have it now. You can proceed.
Okay. My Lord, so from Exhibit 1, we can see that Mr. Agyei-Gyebi wrote a letter of resignation to his Judicial Council of his college. Exhibit 2, there was an acceptance letter from the JC. And Exhibit 3, there was a public notice announcement to the whole public by the JC, which should have taken effect of the 14th of July, 2025. Even with this, my Lord, the opponent is not objecting to the fact that he appropriately resigned as a college president. Now, my Lord, Mr. Gyebi's office as a parliamentarian is derivative, not substantive. He, by the virtue of the fact that he is a College of Humanities and Social Sciences president, becomes a parliamentarian. My Lord, when the substance is taken away, the accessory follows. And I quote this Latin parlance. Sorry, my Lord. Accessorium sequitur principal. That is, when the substance is taken, the accessory follows. My Lord, Mr. Agyei-Gyebi, by virtue of the fact that he is a college president of College of Humanities and Social Sciences, becomes a parliamentarian. And therefore, if he has appropriately resigned as a president of the college, then what is his job in parliament? It is extinguished.
Counsel,
Oh, yeah.
I want to ask a question. You know about the president, right? I mean, you know John Dramani Mahama.
Yes, please.
All right. Sorry, His Excellency John Dramani Mahama. All right. So His Excellency John Dramani Mahama came on the ticket of a political party, right? That's NDC. He came on the ticket of a political party, NDC. So in case John Dramani, His Excellency John Dramani Mahama says that, I mean, he's no more part of the NDC. I mean, maybe he has finished 2 years, and he says that he's no more a member of the NDC. And that, because he's coming on that ticket, right? He's coming on that ticket. So if he says that he's no more a member of the NDC, does it mean that he has resigned? Because the ticket for which he became a president, he came on a political ticket. When on the ballot paper, there's a political party's logo on it. So is that what you are saying?
Respectfully, my Lord, the analogy you are giving is totally different from the scenario we have.
Why is it
here.
different?
It is different because if you had said that he resigning to be a president still made him the commander-in-chief of the Ghana Army, that would have been the perfect scenario. This is because he becomes the commander-in-chief of the Ghana Army by virtue of the fact that he's a president. So when he resigns, automatically, he no more becomes the commander-in-chief of the Ghana Army.
But what is the duty of a commander-in-chief in Ghana? Council, understand, but I'm saying that these two positions, on what, didn't he come on a political ticket before he came into these positions? I mean, didn't he come on a ticket?
We are not disputing that fact.
All right. So but I'm asking you a question. Does it work that if he says that he's no more an NDC person, would it be that he's no more a president of Ghana?
My lord, unfortunately, with the analogy you are making, does not fit into the scenario.
Understand
And
my,
even in
understand,
the
relax. Understand
Afenyo
my
marking
analogy
case,
doesn't work.
even in the Afenyo marking case,
No, I'm coming. I understand my analogy doesn't work, but I'm asking you, like, answer the question.
the court, sorry, councils cannot provide you with that information, especially when it does not work in this scenario.
Okay, proceed.
Furthermore, my lord, with this, as we have already established...
Counsel, please hold on.
All right, Council, proceed.
Okay, so my lord, as we have already established that the substance, which is by virtue of which makes Mr. Agyei-Gyebi a parliamentarian, has been taken away, the necessary is taken away because another analogy we want to give. He has appropriately resigned. Now there's supposed to be an interim president until the handing over for 2026 academic year. My lords, if that person or if that interim president comes to court, are we going to sack the person because Mr. Agyei-Gyebi, who is no more a court president, has not resigned appropriately as they claim? We are not even admitting that, my lord. My lord, if you read 2-4 verses Attorney General, Agyei-Gyebi, because of time I would want to paraphrase. He said that the Constitution must be interpreted liberally and purposively. And with that, we established that our client has resigned appropriately and substantially with regards to Article 96(1) of the SRC Constitution. And Article 129(3) of the 1992 Constitution provides that only the Supreme Court can depart from its ruling, and it is binding on all judicial and quasi-judicial authorities or committees. Respectfully submitted. Sorry.
All right.
My lord,
Counsel for the petition.
we are not done with our submissions. Yeah. My lord, I'm very sad this afternoon or evening that College of Humanities.
Can you, just proceed to
yes,
your
please.
substantive?
It's part of my substantive submission that a college has an interim president, and I could even see her around, and someone who has resigned and we don't even recognize him as a president. A petitioner is here challenging that resignation. But we move. My lord, it is very surprising that I beg to differ. If the petitioner would want us to say that someone can be a member of parliament just because the person has taken an oath of office and the person is neither a college president or a hall president. If that is so, then I beg to differ that our constitution does not say that in any part of its provisions, because it is by virtue of the person becoming a president that gives the person the power to be a member of the SRC Council. So you cannot put something on nothing. My lord, the framers of the Constitution, which in this case...
My lords, with the leave of the court, permit me to object this. I never said that he became a member of parliament just by virtue of being a course president. I never said that, and I expect my learning colleague
My lord, I didn't make that submission for him. I'm making my submission, and I didn't even make their response to that.
Yes, counsel.
But my lord, he did said in his submission that the legal affairs said, the petitioner, the counsel for the petitioner said, of which I didn't say so.
I asked the question that
Counsel. I believe you both acknowledge what just happened right now. You both acknowledge each other. Kindly proceed.
Sure. Thank you.
Thank you.
So, my lord, I would want to also make emphasis on the fact that Article 96 of the SRC Constitution, the 96 one, the intention of the framers was to talk of a substantive matter, not a technical error. Here, in this case, a person has resigned as a president of a college, by which the person cannot even come to parliament to even represent. So if by virtue of that, we should even accept that he has resigned as a member of, he has resigned as a president of the college, but he has not resigned as an SRC parliamentarian. Who is he representing? We have a president who has to represent us. So if by virtue of that, Agyei-Gyebi should be regarded as someone who has sworn an oath of office to be a parliamentarian, and that he is a parliamentarian, he is not a president of a college, that will lead to absurdity. And I would want to make the emphasis on the fact that equity looks at the substance, not the form.
Are you using a maxim?
Yes, please. I'm using a maxim.
A constitutional provision.
I'm supporting it with my argument. Yes, please. So if by virtue of his resignation, he has made those resignations to the appropriate authorities, why are we here to challenge the fact that it has not been communicated to a speaker? Here in this case, I would want to tender an exhibit in support of my argument. I would want to tender Exhibit 6. Exhibit 6, which is the speaker's audio to that effect. Exhibit 6.
Please, is it ready to be played? Is it ready? Exhibit 6. All right, counsel. Hello, counsel. Should it be played?
Yes, please. It has to be played.
All right, when you are ready.
Thank you. My lord, if that is not ready, Exhibit 5 is also part of what I would want to also tender. So Exhibit 5 and 6.
It's a document.
Yes, it's a document.
I don't understand what you're saying. When the person brings the resignation, part of the process that shows that the person has resigned is that the person is not on the page. And just for that reason, I'm taking them off course. I realized that somebody once met me during these elections, and they were saying that. And for a long time, I wanted to, if not the SRC, I would have kept everybody on, but I just want to take them. After the house has been dissolved, we'll add them back by each other. They have to go. I mean, I don't know why course will be denied. The General Secretary is there, and his course will be denied fair representation. How is that true? The person has resigned. The person that has resigned and
please, can you pause at this point?
Which of us is preventing court from having fair representation?
The person has resigned. In this case, all the communication that the speaker was communicating was in respect of Nana Agyei-Gyebi. So he has admitted in an audio that he has resigned. Now, based on Section 26 of the Evidence Act, it says that if someone by his conduct has admitted to the effect that something is to believe to be true. I mean, he's extopelled from coming back to say that I didn't admit. And Exhibit 5 of Exhibit 5, please, have you given it to them? Exhibit
Counsel.
5. Exhibit 5.
So, counsel, permit me, did you use estopel in relation to the constitution, the
audio? Yes, please.
Yes, so
It's a constitutional provision, and we are here challenging a resignation. The petitioner says that the speaker is not acknowledging the notice of any resignation, a proper to that effect. That's what he's saying. And now it's in the speaker's audio that the person has resigned. So which is which? What are we arguing now? The issue is the speaker is making emphasis on the fact that, please, I would want to finish.
continue.
The speaker wants to make emphasis to the effect that the resignation letter has not been communicated to the parliament. And now he's admitting that he has resigned. So what again are we challenging?
I believe
on?
we are interpreting a constitutional provision.
We are not this is an evidence to effect. I'm not talking about a constitutional provision. Yes. I've tendered an evidence, and I'm saying that by his conduct.
Counsel, but when from the audio we all listened to it, he said resign from. Did the speaker add where he has resigned from? Because that's one evidence you have brought. There's also another exhibit. I mean, an evidence that the petitioners brought and said, I mean, from the letter, he's saying that Honorable Agyei-Gyebi has resigned from office as president. So if he says he has resigned without stating where he has resigned from, are you not implying that the speaker meant he has resigned from parliament?
I believe my counsel made a statement to that effect, so I would want her to state it to the court.
Respectfully, my lords, if we listen to the audio well, he said, courts will get representation. The general secretary is there. Is that not necessary inference enough?
Is it only the general secretary that represents courts?
The general secretary and the president. Now, Mr. Speaker is saying that if he has resigned, the secretary can represent. There is fair representation for courts. Is that not inference enough?
So what you are letting us infer is that
yes,
the speaker said he has resigned. So that's what you want to tender. That's all you want to tender, that the speaker himself expressly stated that he has resigned.
My lords, let's not forget.
Yes or no?
Yes.
Thank you. That's all. I understand. Thank you.
And with the Exhibit 5, should the speaker even say the audio is not his voice?
Where's Exhibit 5?
Exhibit 5 has been...
And is the audio?
It was projected, my lord, it was submitted to the registrar. To that effect, so.
Okay, proceed.
So with the Exhibit 5, it contains a message between Nana Agyei-Gyebi and the clerk of parliament. And my lord, it contains a notice of the public announcement which has been given to the clerk. And I believe that the clerk serves under the office of the speaker. In this case, a secretary to the speaker. So if a communication has been tendered to the table office of parliament, that means it has to be communicated to the speaker. So if Agyei-Gyebi has communicated the public notice of his resignation letter to the clerk to be given to the speaker and it has not been done, my lord, I think it shouldn't be something that should go against Nana Agyei-Gyebi because he did the needful.
So are you saying that the public announcement letter that was given to the clerk was the resignation letter?
There is a CC to that effect, speaker.
But are you aware that the Constitution requires that it should be submitted 7 days before the intended date of resignation? Was it submitted?
It is.
Yes, it's supposed to be submitted 7 days before the intended date of resignation. And you are here talking about benevolence, broad, liberal, purposive interpretation. Yes, and we should. Are you trying to say that the framers did not have any purpose for which they said 7 days before the date of resignation? Or are you saying the framers of the Constitution did not have any purpose or did not have any intention behind saying that a member of Parliament should communicate his resignation to the Speaker of Parliament? What if he has something in possession, a property, an SRC property in his possession? Did you hear what I said?
That's why we are making arguments that the purpose of the whole article is that it should give a notice to the respective...
The purpose of what?
The purpose of this whole resignation thing is to give a notice to the respective heads. Is to give a notice to the respective heads. So if he has resigned on a date and a public notice has to be given to the Constitution didn't say that he has to resign to the Speaker. He has to resign as a president. So he resigned days before the 7 days.
Because
so he was within...
There are 4 procedures. First, that it has to be communicated to the head of the council, for which the petitioner is part. Sorry, the respondent.
The respondent is not part of the head.
For which
he's not part.
Alleged.
Okay.
He has served under the 16th SRC Parliament, right?
Yes.
Yes. So in case he's supposed to resign, he's supposed to communicate his resignation in writing to the head of the council, 7 days. And secondly, it has to be copied. No, thirdly, the first one is 7 days. The second one is communicate to the head of the council. The third is that it has to be copied to the dean of students. And the fourth is that upon the receipt, the council head should publish the resignation on all notice boards within 4 days after receipt of the resignation letter. Council, are you saying that all these procedures do not have any intention? There's no intention behind them. They have
my
no
lord,
use.
my lord.
Let me finish.
Okay.
Or are you saying that in making a benevolent or a broad or a liberal construction or a purposive construction of the provisions, your client satisfied these conditions?
My lord,
they satisfied the intention of the framers.
We are basing on the substantive of the whole resignation.
So the procedures in the Constitution should be discarded? Not
that, but we are talking about the fact that the purpose of the resignation is to give them notice.
Council,
I'm trying to make an argument that he has resigned as a president, which has been established. He is not an SRC officer. He is there as a representative of a college.
No, Council,
an SRC officer has been defined in the Constitution.
What does it say?
With the leave of the court, I would want to read. SRC officer means any student who holds office. Emphasis is on office in any of the 3 working bodies of the SRC. Gyebi was not appointed. He was elected to represent a college. Those officers those that are occupying office are the deputy, the clerk, the marshal, the protocol heads that has been appointed in the parliament. Those people...
Are you not important? Because the Constitution says that any student, is your petitioner, is your client a student?
Yes, please.
any student who holds an office in any of the 3 working bodies, did he hold an office in? So what are the 3 working bodies?
So the 3 working bodies is the Executive Council, the Parliamentary Council, and the Judicial Council.
So you are saying that your client was not a member of any of the 3 working bodies?
He is a member of the 3 working bodies, but not holding an office under the council. So, my lord, let's get the distinction right.
Yes, help me.
The speaker was appointed. The speaker has clerks, marshals serving under his appointment. So, are you trying to make a case that should they want to resign, I mean, someone who has been elected by his college, thousands of people, a constitution guiding them to that effect, which this SRC constitution recognizes him, and he has resigned properly under the constitution. What is left in contention is a communication, and that has been done in good faith, because if he had wanted to do something in bad faith, so, he wouldn't have made...
Counsel, your argument is that your client was not a member of any of the 3 working bodies.
Yes
or no, so that we have
my statement is, he is a member by virtue of being elected to represent a college.
So he's a member.
Not holding an office as an SRC. The statement is, holds an office. My lord, holding an office under the working bodies.
What does it mean to hold an office?
It gives when we talk about the leadership of the Parliamentary Council, they have their standing orders. And clearly in their standing orders, the leadership does not entail the members of Parliament. It says the Speaker, the Clerk, the Marshal. Those are the very things it mentions. So he being elected into the Parliament, he's holding an office as a college president, not an office as a member of Parliament to that effect, to be regarded as working under the 3 bodies. But he is a member. He is representing us. So we submit that the writing to the speaker, as he claimed he didn't have that writing or he didn't get that notification, is a mere procedural error. But the effects of the resignation has been read in good faith. And we would want to mention the case of Republic versus High Court, Commercial Division, ex parte par Kusi Indium, and the Electoral Commission. I would want to read Agyei-Gyebi as he then was. Where a party has substantially complied with, my lord, I believe my lord, yes please. Where a party has substantially complied with the procedural requirement for resignation, a minor or technical omission, especially one that does not go to the substance of the act or affect its legal intent, emphasis on legal intent and effect, should not invalidate the resignation, particularly where the omission does not cause prejudice and intent to resign is clear and unequivocal. Rigid insistence on the technicalities in disregard of the substance and surrounding circumstances offends the principles of fairness and administrative justice as affirmed in that case. So please, the purpose of resignation is just to give notice. He has done so. It has been communicated through the clerk, which has to get to the speaker. The speaker has admitted to that effect. He has not held himself after the days as a president in any capacity.
So, Counsel, your alleged instance or your alleged position that your client has resigned, when he allegedly resigned, I mean, from your point of view, has any other person been submitted? I mean, has any other name been submitted to replace him in Parliament?
That's not his duty in that effect. It's the duty of the college executives, the JC, to submit, or the executives currently to submit to the speaker that we have our new president. And my lord, our new president is here. To that effect, she is here.
Sworn in.
Sworn in to that effect. She is acting.
Sworn in by the college JC.
Yes, please, to that effect. And she deals with the provost. She deals with the provost.
Okay.
Nana Agyei-Gyebi does not hold himself out as a president anymore.
So are you saying your client is not receiving any benefits?
Nothing of that sort. Nothing of that sort. Nothing of that sort.
Do you know where he's accommodated? Do you know where he's accommodated?
My lord, we are talking about constitutional matters. And wait, first. We are talking about constitutional matters. And the fact that this,
relax.
he cannot be sacked. That is.
No, I'm asking a question. I'm saying that I asked first that is he receiving any benefits as a parliamentarian?
My lord, no, in the sense that talking about accommodation, I'm coming. Talking about accommodation.
You're not talking about accommodation. I thought you said
no.
We are talking about constitutional matters. And
yes,
we don't
please.
need to talk about
but you veered into that, and I would want to make emphasis to that effect. Please,
Counsel,
accommodation
Counsel,
here.
Hold on, Counsel. You are before this honorable court. Mind your language and your tone.
Yes, please.
Thank you.
My lord, I don't mean to disrespect the court in that regard, but this is a serious case. Even if we do not proceed it with the needed and serious...
Did you apologize and justify?
I apologize to that effect.
Thank you.
So, my lord, I was making emphasis to the effect that the accommodation issue here is, we are here to promote the welfare of students. The Student Representative Council is there to promote the welfare of students. So if, by virtue of the fact that if someone should resign from a position in the intention to promote or in the intention to help shape our SRC to that effect with his vision in that regard,
we should give all the SRC aspirants a room to sleep at SRC hostel.
Not please, but he was there before he resigned. And
so
here the academic
benefits. I'm asking him, is he enjoying a benefit he's enjoying? I mean, he was enjoying while he was an SRC. I mean, he was part of the SRC parliament.
Yes, but in the interest of justice, he cannot be moved out of the SRC room.
The question, no, I'm not. You are just trying to divert. I'm saying, relax. I'm saying that is he enjoying a benefit he enjoys? I mean, he used to enjoy while he was a member of the SRC parliament.
I said no, and I made exception to the accommodation issue, that he cannot be moved out of the room.
Because he cannot be moved out, he's allowed to enjoy it.
He is in there because he is a student and he has to get a place to sleep. So should we say that if someone resigns 3 days to the end of the academic year, we should move the person out of the room to where? And I believe the court upholds human rights and fairness. This is so fair enough that someone has resigned, and just because the person is staying in an SRC accommodation, the person has to be moved out of the accommodation. My lord, I beg to differ in that regard. I beg to differ in that regard. And, my lord, I would want to make a submission to the effect that the role of the resignation in Article 96 is a general rule. It's a general rule to the effect that Nana Agyei-Gyebi, in his case, was a president. And in this case, by virtue of that, he becomes a member of parliament, which is a special situation different from all the officers who has to resign under the SRC. So, my lord, if a notice has been given, whether implied, whether constructive, whether actual, same has been given to the effect. And, my lord, we must not regard the main issue that we are here to contest whether or not he has resigned, because that is the only thing that could lead to his disqualification. And now he has resigned. The only thing that was left, which the petitioner claims, is that it has not been communicated to the speaker. But the speaker in his audio has admitted same. And also there is a letter which has a public notice to that effect, which has been given to the clerk. So, my lord,
Yes, counsel. So we'll be taking a 1 minute, about 5 minutes recess. But before we go, I want to avert your mind to something.
Okay.
Right now, what you are saying is there must have been communication, and communication was done.
Yes, please.
I feel you are moving away from the substance of the case. The substance of the case is there is a provision in the SRC constitution as to resignation.
Yes, please.
There's a provision in his course constitution as to resignation.
Good.
Does the provision in the SRC constitution affect his resignation or make it invalid? That is where your line of argument should be coming from. Not that there has been communication.
My lord.
Allow me to
Yes,
land.
please.
Not that there has been communication and the speaker knows. Does, per the law, be a literal interpretation or a purposive interpretation? Does the resignation under the SRC constitution affect the alleged person, president, or not? That is where your argument should be coming from. So kindly allow the 5 minute recess, get your arguments right, and
my lord,
make
if you
your
permit
argument.
me with 1 minute.
I will not permit you. So
Okay,
allow
sure.
this 5 minute recess,
Okay, sure.
if we may.
Humbly submitted.
Yes, counsel for the petitioners. Let's hear your submission.
Kindly wait, counsel. Before we proceed, I believe it is apparent to you that it is fundamental, there is a fundamental principle of law to promote the independence of the judiciary. Justice must not only be done, but justice must be seen to be done. It must not give the audience even an inkling of doubt in the capacity and the verdict of the judiciary. In light of this, and the inkling of doubt, or the probable inkling of doubt, I would use this opportunity to recuse myself and allow the third deputy judicial chairperson of the KNUST SRC to hear this case.
The only judge with integrity. Thank you, my lord. His lordships, in response to the written submission.
My lord, we were on our feet before the courts moved on reset. So I was thinking, and we are not done with our submission. So I was thinking we granted the needed time to complete our submission before the petitioner comes in. Yeah, but okay, sure. Okay, sure. Much obliged, Your Lordship.
My lords, if I may. His lordships, in response to the first respondent's written submission, which is the substantive matter before the courts, even though my senior learned colleagues are moving away from that. With respect, the first respondent, responding to paragraph 7 of their statement of defense. Paragraph 7 of their statement of defense. With respect, the first respondent's reliance on Article 40, Clause 1, Paragraph E of the SRC Constitution 2021 as amended, for the purpose of clarity and with the leave of the courts, I read Article 40, Clause 1, Paragraph E of the SRC Constitution 2021 as amended. It says the Parliamentary Council shall compose of the presidents and secretaries of JCRCs and colleges, suggests that the membership of the SRC Parliamentary Council is automatically extinguished. This is in response to their statement of defense, which they said that Article 40, Clause 1, Paragraph E of the SRC Constitution suggests that the membership of the SRC Parliamentary Council is automatically extinguished upon resignation from constituent office, is legally unattainable. While Article 40, Clause 1E, which I have read earlier to the court, outlines the composition of Parliament, including the president and secretaries of colleges and JCRCs, it does not negate the procedural requirements under Article 46, Clause 1. Article 46, Clause 1 of the SRC Constitution 2021 as amended, which mandates that every member must take and subscribe to the oath of allegiance and the oaths of member of parliament before assuming their seat. This oath signifies a distinct allegiance to the SRC parliament, separate from any loyalty owed to their constituent units. So the resignation from college presidency therefore does not ipso facto terminate one's parliamentary role unless accompanied by a formal resignation from Parliament itself, as stated in Article 96, Clause 1 of the Constitution. In the case of Michael Ankuma Nifa versus James Jachi-Kwesen, the Supreme Court of Ghana defined allegiance as loyalty owed to authority, superior, group, or cause. Applying this reasoning, the allegiance owed to the SRC Parliament by virtue of the oath and function is separate and independent from that owed to the college constituency.
Counsel, are you saying that it is the oath that makes him a member of Parliament?
My Lord, respectfully, by virtue of Article 46, Clause 1, with the leave of the courts, I'll read.
Permission granted.
Procedure in Parliament, Article 46, Clause 1. A member of Parliamentary Council shall, before taking his seat in Parliamentary Council, takes and subscribe before the Speaker the oath of allegiance and the oath of a member of Parliament, Parliamentary Council, set out in the third schedule of this Constitution. And if I may proceed, like I was saying.
I'm coming. Can you realize that the Constitution called that person a member of the Parliamentary Council before adding the rules that the person has to take and subscribe to? So it means that even before the person takes and subscribes the oath, subscribes before the Speaker, the oath of allegiance and the oath of member of Parliamentary Council are set out in the third schedule, the person is already recognized by the Constitution as a member of Parliamentary Council. Do you agree with my position or not?
My Lord, respectfully, I do not agree. The reason being is that you can, if by the provision of Section 40, Clause 1E, or the provisions of Section 40, Clause 1, which lists the composition of Parliament, if that is the only criteria that makes you an automatic member of Parliament, then the instance or the case of Master Alexander Kpevu should be recognized as a member of the 16th Parliament, because Grassack President is supposed to be part of the composition of the SRC Parliamentary Council of KNUST.
He's a member. He's a member, but he just chooses not to come for the sitting.
My Lord, he has not been recognized as the Speaker in his petition. He has not been recognized as by the Speaker to be part of the 16th Parliament, and as such, is not performing any parliamentary function or receiving any benefits to that effect.
No, he is. I had personal interactions with the Speaker, and he said he's recognized as a member, but the only thing the Speaker can do is compel him to come. To tell him to come. But he's recognized as a member because the Constitution allows him to be a member.
My Lord, I don't think if it is not necessary, the framers of the Constitution will put Article 46 one day. It is a constitutional requirement that even though by Article 40, Clause 1, Paragraph E, by virtue of winning an election from the constituents you are coming to represent in Parliament, you are required to be sworn in as a member of Parliament to owe allegiance to the SRC Parliament, which is different from the allegiance one is going to owe to the constituents they represent. And as such, the functions of the SRC Parliamentary Council, which composes of these presidents and general secretaries of the various colleges and JCRCs, are not the same as the functions they perform at their various constituent units. When they come to Parliament, their functions they perform are not the same. So if they are there by reason of being elected by their constituent members only, then they should be there to perform those functions spelled out in their constitution, and not to take the oath of allegiance to perform the functions spelled out in the SRC constitution for them to pay their loyalty to the SRC, as well as So that is why before the swearing in, they are seen as president-elect or president from their various colleges, but not members of parliament, properly so called. Furthermore, the conduct of the past aspirants reinforces this procedural norm. Individuals such as Nisi Agyei, with the leave of the courts, will tender Exhibit E.
Did you give it to them?
Yes, please.
You did?
Yes, please. Exhibit E.
Do you have a copy of Exhibit E? Soft copies, right?
Nisi Agyei, who was sworn in as a member of the 16th SRC Parliament after winning an election to become the General Secretary for GISA, which by virtue of Article 40, Clause 1, Paragraph E, became a member of Parliament, but later, after resigning as General Secretary at GISA constituency, also resigned as a member of Parliament in the 16th SRC Parliament upon filing her nomination to run for GISA president earlier this year. Again, Ms. Kekeli Wolinam in Exhibit F, with the leave of the court, would like to tender that evidence too. Who was sworn in as a member of the 15th SRC Parliamentary Council after winning an election, became a the election to become the General Secretary for the Independence Hall, but later, after resigning from the General Secretary position in Independence Hall to contest for the SRC General Secretary position in 2024, also resigned as a member of the 15th SRC Parliament upon filing nomination to contest for the office of SRC General Secretary in 2024. Then, the likes of Michael Agyei in Exhibit F, if the court will permit me to tender in those evidence, and Kelvin. I combined them together. So give Exhibit F. Add this to it. Exhibit F. Michael Agyei. This. Let me see. Exhibit E. No, B is not part.
Copies of all of them. You do? You said? All right. Okay, Council, we've received them.
Ohiniku, yeah, my lord, I'm continuing. Ohiniku Kelvin, also in Exhibit F, all resigned from both their constituents and parliament prior to filing nomination for new offices. This consistent practice affirms that resignation from the office does not automatically extinguish the other, and that procedural compliance with both is required to uphold the constitutional integrity. Then, my lord, in response to paragraph 8 of the respondent's statement of defense, respectfully, the first respondent's concession that the dean of students was not, the first respondent's concession that the dean of students was not copied on the resignation, though characterized as procedural, is not mere technicality, but a substantive breach of the SRC Constitution of the Kwame Nkrumah University of Science and Technology. Article 11, Clause 1E, with the leave of the courts, I would like to read. Unequivocally provides that.
Relax.
Article 11, Clause 1, Paragraph E, unequivocally provides that he shall not be an officer holding any position under the SRC at the time of filing his nomination, the omission to properly notify all relevant authority, particularly the Dean of Students, undermines the validity of the resignations and leaves the status of the first respondent as an SRC officer unresolved at the time of nomination. The Constitution requirement is not satisfied by partial or informal step. It demands full compliance with prescribed process to ensure transparency and institutional accountability. Then again, in response to the 5th and 6th paragraph, which has again been asserted in this honorable court today, without prejudice to the defendant's purported resignation, it is respectfully submitted that conduct and representations are essential in determining one's continued assumption of office, notwithstanding the claim that Mr. Nana Agyei-Gyebi, through the judicial chairperson, issued a public notice on his resignation as course president or the president for College of Humanity. He continued to perform core presidential duties thereafter, if with the leave of the courts, as seen in Exhibit G. Tendered in...
My Lord, I would want to object to this exhibit to the effect that this is a mere picture showing...
No, but the court has not even seen...
I've seen the exhibit, so I thought...
Relax, let me see so that I can follow you.
So
my Lord.
If I may continue, my Lord.
Please, that was not even admitted
Tendered,
in the first place.
It wasn't sent to you.
No, we have no picture.
My Lord, I sent it. I sent it to you, my Lord. I sent it to you yesterday, my Lord.
Let my registrar confirm.
Okay, my Lord.
But if it is, how did you know the content of the document?
So
you have seen something on it.
My Lord. My Lord,
No,
please let him proceed. Let him proceed.
No, sit down. Yes. Did you? Hello. Are you? Let me question. Hello. Let me ask you. Counsel, are you called Anochiwa? Can you confirm this number if it is your 027-195-3560?
My Lord, like I said, he should proceed.
Okay.
Yes, that is what I said. Yes, he should proceed.
Okay.
My Lord, to proceed, as my senior learning colleagues have admitted, in attempts to throw dust in the eyes of this honorable court that they never receive our evidence, I will continue to say that...
But do you have a hard copy so that... Do you have a hard copy?
Yes, please, my Lord. Yes, please. The exhibit captured Mr. Agyei-Gyebi alongside with other College of Humanity executives representing recently won trophy to the provost of the college on 25th of July, 2025.
Counsel, are you saying that the day they posted it is when they presented it?
My Lord. My Lord.
Please, what is...
That is what I am asserting.
But I don't know how we will be able to accept assertions over here without proofs.
My Lord, taking the wording or the caption, he says, course emerged as overall winner for 2025 Intercolleges game, winning 10 out of 20 trophies. And posting it on the said day, my Lord, it's reasonable to believe that he was still operating as the president. 25th of July, 2025 is an act which shows that he's still serving as president.
No, I don't think so. I don't think there's any... I don't think you are leading enough evidence to prove that it was... The fact that they posted it on 25th July 2025 doesn't mean that that was when he exercised that duty. So when was the inter-colleges game? When was it organized?
My lord, we apologize for that assertion.
But I'm asking, when was it organized? Do you know when it was organized?
My lord, we would have to confirm
Yeah, I'll be
that for
waiting.
you.
Please be fast with it.
This your phone. Open the SRC group for me.
I'm not in the SRC group again. I removed myself from it.
It's not possible, right? It's not possible to get that information. No, but I think it will take much of our time. So let's proceed.
My lord, with the leave of the court, I'll finish the court once I get the information.
Yes, we are waiting.
My lord, humbly submitted. We'll finish the court as soon as.
You are done with your submission?
For now, we are done with the responses to their defenses on the
Okay.
statements.
You said you wanted to say something. You had a submission to make. Or you don't have any more?
My lord, sorry, but we've chanced on.
All right. When was it organized?
It was organized from the 14th to 21st of July. And on his said resignation letter, he resigned on the 14th when the program was organized.
Okay. Let's hear you. You don't want to talk again?
Objection. Your Lordships, the petitioners will want to say that the fact that he has resigned means that he cannot attend the program, which is a wrong inference.
My lord, we object that because we did not say he attended the program, but this is a ceremonial function he was performing here, joining a group of executives to present a trophy that was won after his resignation, my lord.
So please can the picture be displayed? Is the other guys, the other people in the picture, are they all executives? Are they? Yes.
My lord, I was raising an objection to the effect that he is not a sports chairperson.
Who is not a sports chairperson?
Nana Agyei-Gyebi is not a sports chairperson. He's saying that he's performing a ceremonial function. And my co-counsel here made a mention to the effect that because he has resigned, does it mean he cannot attend such programs?
But
so it could have been that clearly the sports chairperson was around presenting the trophy to them, and he just joined them as a member of the college.
So who are the other people in there?
The other people there is the organizer of the college, the women's commissioner, the sports chairperson is there, and other members are also there. So are you trying to tell me that if we've gone for a college, I'm coming, please, I'm on my feet, please. I'm on my feet.
But you're not the one to tell him that.
I'm sorry.
My lord, if the person projecting the picture can scroll.
Finish. No, let me hear you.
And so I was making the argument that if the sports chairperson who is in charge of sports has won trophies and is going to present it to the college provost, and he, as a resigned or as an immediate past president, seeks to join them just to show appreciation in that regard, because nothing of this post shows that the course president has made presented a trophy. Nothing of that sort is to that effect.
Okay, I've heard you. Do you have any response?
Yes, please. If it pleases the court.
My Lord, objection. The council here was not presented to us as a member of the council. And when we were making records, she wasn't also present in this court. But she's taking a microphone to make a submission. I don't know of her capacity.
Yeah, please introduce her.
My Lord, she is a member of the 6 members of the Legal Affairs Commission.
Okay.
My Lord, he has to prove that to us because the appointments, they have a list of their people. Even a page could show. So he should prove in the Legal Affairs Commission.
Does she even need to prove to you that she's a Legal Affairs Commissioner before she can defend someone in a case?
My Lord, we started this case.
Who
presented.
did you prove yourself? What did you say you are? What proof did you?
We announced our presence in court.
Yes, and that's the same thing that has been done for her.
Okay, sure.
Yes.
Okay. My Lord, if it pleases the court, right, per the assertion my senior counsel and his team are making, it's that he randomly went there as a college member to be the one at the forefront, whilst the general and the vice president, the women's commissioner, and the organizer who excused him, as at the time, him being an ordinary college member, for him to be the one to make that presentation. Honestly, if we are simply judging by the pictures, then I don't know why they are trying to tell us that. So with the honorable organizer, women's commissioner, all those leaders of the college were there, and they allowed a random person present the trophy to the provost. Is that how it should be? Because if that is the case, I'm very confused.
Oh, please, can you people be quiet so that we can proceed swiftly? Yes.
Objection. This is just one among many pictures. We don't know if the rest of the pictures they presented. He just wanted to take a picture with them. We cannot reasonably infer that the fact that he's
presenting the trophy, not taking the picture.
Okay, that's what I said. This is an honorary invite, and this is one among many pictures. There may be other pictures that the respective person supposed to do it took their pictures, but were not posted on the.
Okay.
Yes, my Lord, I would like to. If there are other pictures, right? This was posted.
This is the last submission from you.
Yes,
so
please. This was posted on the official college page. Do you get what I'm saying? So does that mean that they deem the picture of a random college member more important than that of those of the other college executives if they were taken? No, it's on the official college page, except, of course, this is not the official college page of the College of Humanities and Social Sciences. Then I would like to be corrected. But if it is the official page, and then they were all well aware of this picture and it was put there and nobody raised an objection to the post, then that means that they are putting it there for everybody to see. Other than that, are you trying to say that a random college member has a higher portfolio than our distinguished women's commissioner or our organizer? No, you cannot say that. So I don't understand why you want to present it as if, oh, it was just a random something that he did for them to take pictures and post. Yes, please, that's my humble submission.
Do you have any other submissions?
Yes,
not on this matter.
Yes, ma'am. Not on this matter.
Yes, not on this issue with respect to the exhibit.
Okay, but my lord, I just wanted to say that she should realize that he's not just a random.
Oh,
he's the immediate past president.
I just said not on this matter.
Okay. So with the allegiance aspect or submission that my opponent made, I think he didn't really digest the micro-nympha case. Because if he did, then he would realize that the court also said that allegiance can be lost when a party does not show any form of commitment to the supposed institution or committee. In this case, my lord, there was a trip to Parliament, Ghana Parliament, and Mr. Agyei-Gyebi was not there. Again, Mr. Agyei-Gyebi, by WhatsApp message, sent a resignation letter copying the Speaker of Parliament that he has resigned.
Did it get to the Speaker?
That would be an administrative error from the clerk and not Mr.
But who
Agyei-Gyebi.
did he send it to? Did he send it to the
The
clerk?
clerk of Parliament, Fisker.
No, the resignation letter that was copied, that is, the Speaker was copied, was it sent to the clerk, or it was sent to the judicial chairperson of the College of Humanities and Social Sciences?
No, my lord. It was sent to the
You
clerk.
don't need to be shouting. I can hear you if you speak loud. If you speak.
Sorry, my lord. It was sent to the clerk of Parliament. Yes. Fisker.
What was sent to the clerk of Parliament?
The resignation notice that copied the Parliament, Speaker of Parliament. Sorry.
Who wrote that resignation?
The JC.
But
Of
is that
course.
what our constitution says, that the JC is the one supposed to communicate the resignation to the Speaker or the clerk?
His resignation should be communicated to the Speaker
All right,
of Parliament.
I'm not sure you are appreciating the provision. 96. 96 says, any SLC officer, not the GC or the SLC officer, any SLC officer shall communicate his resignation in writing to his respective head of council under the SLC 7 days before the date of resignation and copy same to the Dean of Students.
My lord, it didn't make mention of whose letterhead should be on it. In this case, Mr. Agyei-Gyebi is the one who communicated it to the clerk. It was in the letter that...
It was Agyei-Gyebi's letterhead.
Agyei-Gyebi no longer has a letterhead. He's
Okay,
nowhere.
did you receive their... Is it what? The public announcement letter. Did you receive the public announcements letter? Whose letterhead is that?
Yes, my lord, that is what I even wanted to draw your attention to.
No, but I'm asking here, I'm not, yes. Did you receive the public announcements letter?
Yes.
Whose letterhead is that?
Course.
Course has a letterhead. Okay,
Yeah, it was a course letter.
All right. Whose name is written down? Did you check the names down? Because it's mostly, because the letterhead used in the 2024 administration is not the same letterhead used in the 2025, but they are still course. So the juxtaposition is based on whose names are under. So I'm asking again, whose names were under?
My lord, respectfully, we implore the court to look at the substance and not the form. Here, the Speaker of Parliament was copied.
So,
And if...
Council, are you... Yes, with respect to talking about the substance, what do you think is the substance of Article 96?
Resignation.
Resignation. So,
Yes, please.
resignation.
Yes.
But the provision says that an SLC officer shall communicate his resignation in writing to his respective head of council under SLC 7 days, under the SLC 7 days before the date of resignation, and copies him to the Dean of Students. 3 instructions. And the main import of that is just resignation.
Yes, my lord.
All right.
The import of Article 96.1 is resignation. The fact that whoever is the SRC officer no more holds that position again. That is the main substance. Now the rest will be deemed as procedural.
So
and I implore this court.
Someone can just resign from Parliament without even informing the Speaker. How do you expect the Speaker to know that the person has resigned? And whether the Speaker, do you know that the Speaker, I don't know, but I think that the Speaker can choose to reject the resignation or not. Because in an instance, it's just my opinion, in an instance where maybe an SLC officer has, maybe there's, SLC properties are in his custody, and the Speaker does not think that the intended date of resignation, which the Constitution says must be written in that, must be, no, the resignation letter must be submitted 7 days before that resignation letter. So 7 days before the date of resignation. So if the Speaker doesn't agree that the person should resign on this, it could be possible that the Speaker does not agree on the date of resignation, because maybe there's a property, maybe there's an SLC property in the SLC officer's custody, the Speaker doesn't deem that that date of resignation is the appropriate date of resignation, or should be the appropriate date of resignation.
Okay,
What do
my
you
lord, I get your point that he may want to reject. But then when we turn back to Exhibit 6, now we come to his recording where he, by his audio, accepted. Not as in accepted, but then has recognized. And in fact, my lord,
I've not asked that it should be played. But yes, you're making a submission.
and also the Speaker of Parliament would not have the authority to decline a resignation. Yes.
He doesn't have the authority.
To decline a resignation, my lord. And my lord. Okay.
The Speaker is also saying, in his letter, that there was no resignation from. The Speaker, there was no resignation from the Honorable Member, and the Honorable Nana Agyei-Gyebi is still a Honorable Member of the 16th House and should be disqualified with immediate effect. Yes, so the Speaker is saying that he did not receive any resignation letter from Nana Agyei-Gyebi, and that's what the Constitution mandates, that he should have sent a resignation letter to the head of the Parliamentary Council. And like I've been asking, don't you think that there's a purposive, there's an intention of the framers with respect to the fact that the framers want the office to be vacated in the proper manner so that another person can succeed that office?
Respectfully, Your Honor, I would want to answer your question one after the other.
All right, I'm listening.
So with the first that he had not received, we would want to say that that is an administrative error because we had
that is an administrative error on whose part?
On the part of the Clerk of Parliament.
But it wasn't sent to the clerk. The resignation letter was not sent to the clerk. So what do you want the clerk to send?
Respectfully, my lord, it is like we want to go into the details of how a letter should be like.
No. It's about who is writing the letter, because the letter that was communicated to, the letter that was sent to the clerk was written by the judicial chairperson, but not the SRC officer.
Now we come to the substance of 96.1, resignation, which was communicated by Mr. Agyei-Gyebi to the Clerk of Parliament.
There are procedures. You are telling me that the procedures should be neglected, and the petitioners, petitioners have filed. Petitioners have filed. Evidences to prove that previous people have been doing it. It's conventional that a lot of people. Others have submitted a resignation letter to the Speaker himself, not from the Agyei, because Nisi Agyei-Champon has a GISA, there's a GISA JC who should have rationally submitted the resignation letter to Papachi. But that is not the procedure in the Constitution.
My lord, this is what brings us to the case of Republic versus High Court, ex parte, Electoral Commission, and Papa Kusi Indu. My lord, the court stated that when an act, it was an election petition too, so it fits right in these shoes.
Why?
When there is a technical or procedural omission that does not go into the substance of the matter, then the court should be benevolent, liberal, and purposive, as also stated in the case of Tufo versus Attorney General.
Understand. It's not. Have you averted your mind to the fact that it is not just one, not a technicality, but there are four of them that were not done. And I also want to refer you to Georgina Wood's case in Republic versus Fast Track High Court, which says that the purposive rule is not a carte blanche for rewriting legislations. Are you listening to me? Yes, it's not a carte blanche for rewriting legislations, let alone our constitution. And it should not be used as a ruse, a clock, or a guise to do so. The function of the court is to interpret legislations and give effect to it, even where the terms appear unpalatable. And now, there's also a case for Agyei-Gyebi versus Attorney General in Akwete, 2005-2006, Supreme Court Ghana Law Report 732. The court stated that a purposive interpretation does not mean that we should discount the text. A purposive approach will only be used when a literal interpretation will lead to absurdity. So I'm also referring to some other cases.
Yeah, my lord. So we acknowledge the fact that these four are formalities. Respectfully, my lord, this court is a court of equity and a court of law, as stated in the case of Bauchedid versus Yali, which I know very well that you are aware of. My lord, will the fact that these formalities were not complied with go into the root of the fact that Mr. Agyei-Gyebi has resigned? If today we overturn his candidacy, does he still become the president of College of Humanities and Social Sciences? Substantially, he has resigned. Substantially, the SRC Parliament will no longer accept him or recognize him as a parliamentarian. So, my lord, with equity...
I want to explain that there are two different positions. He has two different rules. You get it? And being a college president, having to be the college president before you can become a member of parliament is just a rule that determines how he enters parliament. But there's also there are also a set of rules that define how he must leave. You get it? So the standing orders has how parliamentarians can be removed. It also has, even the resignation, how he must resign. You get it?
Parliamentarians?
Yes.
Is it parliamentary appointees or parliamentarians?
No, there's a parliamentary council. So 96-1 would apply.
Not the standing committee, because I have
no... 96-1.
So we don't have any standing committee of parliament that tells parliamentarian how to resign.
I'm trying to say that there's a constitutional provision that explains how someone should enter into parliament, and it also explains how someone should leave parliament. So you agree with the rules about entering, but you don't agree with the rules about leaving.
My lord, we are saying that substantially, the word is substantially here, my lord, and we implore the court to put in equity as they are deemed or at their discretion, they can do so.
Equity in interpreting constitutional provisions.
My lord, the court is a court of law and court of equity in Bauchedid versus Yali.
No, the Supreme Court has expressly stated that rules of equity cannot be used in interpreting.
Yes, that is why I said at your discretion, if you heard me right.
There's a binding authority over me that we cannot use equity rules to interpret constitutional provisions.
So, yes, this is where we come into 2-4 and Attorney General, where the court said that in interpreting the Constitution, you have to be benevolent, you have to be purposive. Sorry, my lord. So that we...
I don't know, but you're taking me back. It's not like we are arguing, or it's not like, yes, I'm trying to, that's how best I can do to obtain the right information from you so that we can make a very good judgment.
Yes, this is also my best way of letting you know.
Thank you. Yeah. So I'm saying that in Agyei-Gyebi versus Attorney General in Akwete, the court says that the court stated that a purposive interpretation does not mean that we should discount the text, right? And a purposive interpretation is only used when a strict interpretation will lead to absurdity. Then Georgina Wood in Republic versus Fast Track High Court, Accra Ex parte Trash, 2008, GMG 1, page 45, stated that the purposive rule is not a carte blanche for rewriting legislations, let alone our constitution. And it should not be used as a clock or a guise to do so. The function of the court is to interpret legislations and give effect to it, even when the terms appear unpalatable.
Yes, my lord.
But, yes, and have you also averted your mind to the fact that the college president was not only performing, right? One of his rules is that he's supposed to represent the people of, yes, but he's also working at the SRC level. I think they said he's in one of the standing committees of parliament, right? And that standing committee is a parliament, it's an office where decisions are made for the whole KNUST students, but not just the people, of course.
But my lord, he's there by virtue of the fact that he's a course president.
That is how you enter.
Yes.
That is how you enter.
Yes.
That is how you enter. But in exiting, there are also rules for exiting.
My lord, please, I want you to take note of the case of Republic versus High Court, Electoral Commission and Pakwesi Indom, ex-party Electoral Commission and Pakwesi Indom. It goes as early as 2016. So, my lord, if they are saying that we should interpret the same court, the Supreme Court of Ghana is telling us that we should interpret it purposively with benevolence. And they did same, they applied same in the case of Republic versus High Court ex-party Electoral Commission in 2016.
Council, understand, I very much understand. But what do you think is, what do you think would be a purposive reading, of Article 96.1? Because I believe that a purposive reading would prioritize the fact that the speaker must know that one member of his council is leaving, and to also enable the fact that there should be right successory methods. You get it?
My lord, now this comes to the substantiality of it. It seems that when you were speaking, when you were talking about the message sent to the clerk, it was about who addressed it, those exactly like you are saying. So when we are to explain it purposively, like you are saying, the purpose of 96.1 is to resign. So, my lord, he has vacated his seat as a parliamentarian by virtue of the fact that he is no more a course president. So in my earlier submissions, I even put up a question that now, if Mrs. Dadzi comes to parliament during their parliamentary meeting, and Mr. Agyei-Gyebi also comes, like, who is going to be the
Mr.
parliamentarian? Mr. Agyei-Gyebi. Mr.
Why
Agyei-Gyebi.
not? Why? Yes, Mr. Agyei-Gyebi. Why not? Why don't you think so?
Mr. Agyei-Gyebi will be the parliamentarian. Yes. No, he's no more representing COS. College of Humanities and Social Sciences, by the publication made by our judicial chairperson, is no longer a president, and therefore he cannot represent us. That would be oppression, my lord. He can no more represent us. So he can no more enter parliament. So in fact, his seat has been extinguished. And that was the things they were talking about in their e-chamber, where our Speaker of Parliament, Right Honorable Papache, stated that still there will be fair representation because the secretary is there. And actually wished him good luck. That's my lord. So purposively reading Article 96.1, he has resigned. And we implore the court to actually be benevolent and fair and just.
Yes, but I don't. Do you think that the information or the information about the person who has now been, has that person been sworn in as a president?
My lord, that would not be our client's business.
Yeah, but I'm asking.
I have no idea.
Okay. So you don't think that he has been sworn in?
Come again?
You don't think he has been sworn in?
My lord, I'm here for my client. My client is no more the course president. So I think maybe the judicial chairperson should be subpoenaed to answer that question.
Okay. Yes, so I'm saying.
Council.
Yes, please.
Do you believe that there are committees on the SRC Parliament? Like in the SRC Parliament, there are committees in the SRC Parliament?
I believe so.
And do you know that members of the SRC Council members of the SRC Council are made heads of the various committees?
Yes, please.
And for instance, if maybe someone holds a position as the head of a committee, by virtue of just resigning from presidency at the college level, does that mean that whatever documents or information he has in his possession, he can just vacate office because he has resigned from the college level as president?
Respectfully, my lord, Mr. Agyei-Gyebi came to Parliament to represent us. That is the priority, to represent us. Now, Parliament, by his good deeds, even gave him a head of committee. Then, by communicating to the clerk, the space has become vacant. They are supposed to request for every information that he has. And that is supposed to be parliamentary matters. I mean, the Speaker of Parliament asking for my information back.
Please, do you think that the Speaker or whoever in Parliament can request for any information from any head of a committee?
Sorry, please, can you come again?
Do you think the Speaker or any member of the Parliament can request for any information from a head of a committee?
Please, that is the question you actually asked me. So you said, so aren't they supposed to take? And I'm trying to say that if his seat has become vacant, he's no more needed in Parliament. So they can request, if in their standing orders they are supposed to request, then they can do so. And my lord, I am probably not familiar. I'm definitely not familiar with parliamentary matters with regards to their standing orders and all that. So I may not be able to say for sure that they can request. But if that is what is in their standing orders, then they can request.
All right. So, Council, I want to ask once again. Yes, so Article 96, any SRC officer shall communicate his resignation in writing to his respective head of council under the SRC 7 days before the date of resignation. Is it? Yes, his resignation. Before the date of resignation, and copy same to the Dean of Students. Now, 96.2 says that the council
My
from
lord,
which...
Respectfully.
Let me finish. You don't want to
I'm trying
finish.
to object to you reading the two because the petitioner did not come under 96.2.
Yes, but
Yes,
we are
please.
making an interpretation.
Okay.
Yes, we have to. If we are making an interpretation, we are supposed to consider everything together. The council from which the officer resigns shall publish such resignation on all notice boards within 4 days after the receipt of the resignation letter. Are you listening to me?
Yes, I'm listening to you, my lord.
Yes. So the council from which the officer, let me read it again. Please pay attention to me and let me read it again. Any
I'm reading
SR,
with you, that's why it might seem like I'm not looking at you. I'm reading
any SRC officer shall communicate his resignation in writing to his respective head of council under the SRC 7 days before the date of resignation and copy same to the Dean of Students. The council from which the officer resigns shall publish such resignation on all notice boards within 4 days after receipt of the resignation letter. Council, is there any of them, okay, let me list out the rules. Okay, I'm sure you've heard the provision. Is there any of them that you think that your client satisfied?
Yes, please.
All right, which ones?
With resignation in writing to the respective head, with this one through his office desk.
What is his office desk?
The clerk.
No, the provision says that any SRC officer shall communicate his resignation, his personal, his resignation in writing to his respective head of council. So the SRC, number one, is the SRC officer that is supposed to communicate that resignation. Oh, hello, are you? Yes, I'm asking a question. I'm saying you understand that it means that the SRC officer should be the one communicating his resignation in writing to the respective head of council under the SRC. And it has to be done 7 days before the date of resignation. The date of resignation means that the intended date of resignation. And copy same to the Dean of Students. Are you saying that we should... What kind of precedent do you expect us to be setting if we are going to put aside every procedure in this provision?
My lord, we had already submitted with my co-counsel's submission that Mr. Agyei-Gyebi was not an SRC officer.
He was not an SRC officer.
He was an SRC officer ex officio by virtue of the fact that he's a course president. So now if the substance is taken away, he's no more an SRC officer.
That's why I'm saying that the Constitution, by virtue of the Constitution, that provision merely defines how the person should enter the office.
My lord, I'll
Right.
let my co-counsel answer this question
I'm
because
speaking to you. Okay.
yeah, we are team.
Yes, so I'm speaking.
Okay, my lord,
Oh,
I think
I'm
I
s-
made.
Yes, so that provision outlines how the person should enter the office, right? It merely defines how he holds the office or enters the office. Then there are also set of rules that defines how he has to leave or how he could be removed from the office.
Okay, my lord, I think I made this submission earlier on that SRC officer, as it has been interpreted in the Constitution, means that any student who holds an office in any of the three working bodies of the SRC. Now, let's break it down. He was elected as a member of parliament, as a college president. Then, by virtue of that, he became a member of parliament. So if we are trying to equally say that he is an SRC officer, how are we going to describe Masha? How are we going to describe the clerk?
They are all SRC officers
Good.
because they are working under a
They
parliamentary
were
council.
appointed to that effect.
Yes, and an SRC officer can be appointed or elected.
Elected as, he was elected as a president, and he came to parliament by virtue of that. So the SRC president didn't
Yes, so
give
he
him
comes,
any appointment.
Yes, that's what I'm saying. It's about how he entered. So he entered based on election.
Good. So he has entered.
Yes.
By virtue of entering, he is
A
just
member
a
of the
representative.
parliament.
Good. A representative for a college.
Yes, and
Not
it's a member.
holding an office as an SRC officer. There is two distinctions here.
No, he's holding an SRC officer is anyone who works under the parliamentary council, the executive council, the judicial council.
Does the marshal vote?
No, he doesn't.
Does the clerk vote?
No, he doesn't.
So
Why
he,
all SRC officers vote in parliament?
I'm talking about
The president's an
they,
SRC
they are
officer.
not
does he vote in
they are
parliament?
not officers. They are elected members to represent their college. So by virtue of that, they are not equally as the marshals. That's the reason why they have voting rights, because we gave them the power to go there.
Yes, but he's an SRC officer and is working. That's why I said that he's part of a standing committee.
He
right?
wasn't part of any
No,
of the
he's-
standing
he's
committees.
part- I
Objection,
think
my
he's-
lord. Objection. For my senior learned colleague to say he wasn't part of any committee in parliament is not accepted, because to the best of my knowledge, he was even the deputy chairperson for Residence and Welfare Committee in parliament.
He doesn't, my lord, my client doesn't have any appointment to that effect. So
He's a member of a committee that works for SRC.
Good. So he is a member, a representative. So he being a representative,
that's why
qualifies him to be a member. So, my lord,
He
I
has two
cannot.
duties:
Good. So I cannot.
working under the college and also working under the SRC.
Good. So are we trying to make a statement that because I'm trying to make a statement that the SRC constitution have due regard to the course constitution. That's the first point that we've established. And we are saying that he has resigned under our constitution. We've made a public notice to that
You're now
effect.
diverting argument. You're going to another argument, right?
Yeah, I'm trying to say that I'm trying to build the argument on to what we are arguing now.
But that's a different argument.
No. I'm trying to
You
build.
proceed.
Yes, please. So he, by virtue of that, becomes a member of parliament. We've established that one. So he becoming a member of parliament, that gives him the power to be part of the committees. Do you get that?
Committee working for SRC.
Committee working for SRC parliament, not okay. Committee working for SRC, but he's not. The committee is not an office.
What is an office?
He doesn't have appointment letter to that effect. So are we trying to meet?
You can only get an office if the president has an office but was not appointed.
He was elected into office as a
Yes,
president.
and that is why I'm saying that he was elected as a college president. And
Good. So he holds
Let me
his
finish,
office
let me
at the
finish.
college.
He was elected as a college president, and that college president is the ticket for which he enters. You get it? So that ticket is with him, and it is the reason for which he is a member of parliament, and it's for a reason for which he holds an office under SRC, because he was elected by a group of people. And
Yes, please.
you cannot, it's not only about the executives, the welfare commissioner, the SRC commissioner, the transport commissioner are all SRC officers, but they were appointed.
They were appointed.
Yeah, so it's not only by elections. You can be appointed too.
So are you trying to mean that, you see the constitution of the SRC, he knows the constitution in the wisdom of the framers, made executive council, and they also made a distinction between the executive council and the executive committee. The executive committee members are elected, which is the president, the general secretary, the financial secretary,
Help me
and
with
the
that.
women's
Where's your authority?
It's with the leave of the court, I'm trying to. Good. So Article 21 says that the executive committee shall be composed of the president, the vice president, 21:1. The executive committee shall be composed of the president, the vice president, the general secretary, and the financial secretary. I'm trying to make this argument to the effect that when we come to parliament, we have the leadership of the house as distinct bodies from those that were elected to be members of parliament. There are two distinct bodies. So now, he being there cannot be said to the fact that he is just as equal as the leadership of the parliament, which
no
they were appointed. So I'm trying to mean that they are SRC officers, which they are supposed to resign to the speaker. So if a marshal wants to leave parliament or resign under parliament, his respective head of council is the speaker of parliament, because the speaker, he was appointed under the office of the speaker.
So under the committee that he was part of, he was the deputy what? Welfare. Deputy what?
Deputy chairperson for chairperson for Residents and Welfare Committee, and again was a member of the Privilege Committee of Parliament.
Okay, so
my Lord, we don't.
Let me finish. Under these two committees, was he serving the College of Humanities or he was serving the SRC?
He was serving the College of Humanities because.
And he was, I think, he's also part of the Constitutional Review, ad hoc committee for the Constitutional Review or something.
So he is not there serving.
And that's serving SRC. Constitutional Review for the SRC Constitution.
Faculties are serving. Everybody is serving. But I'm trying to make emphasis on the fact that he being there, we are all trying to uphold the welfare of...
I don't agree with your position that he's not an SRC officer, even though he is working under the SRC. He's part of the SRC. It's called SRC.
So, my Lord,
SRC Parliamentary Council.
If we should form a committee, let's say we should have a council.
And that's the legislative arm of government. Too.
Yes, let's say we have...
very serious arm of government.
Yes, please. So let's say we have a council. Then we just form a committee to that effect. Are we trying to mean that because we formed that committee, we've given them an office to operate on? Do you get that? So I'm trying to say that we have a composition, and out of our composition, we are saying that because we want our work to work in a swift way and in a fastest way, we are forming committees. Do you get that? We are forming committees. So are you trying to make a submission that because we form committees, we've given them appointment letter and they should hold, so Gyebi is holding an office as deputy?
The committee members are members of parliament. It's not any student that is taken to be part of the parliament.
So are you trying to mean that Gyebi doubles as the president of the college? He holds an office as the speaker, the member of parliament. He holds an office as deputy, or what we do call it, residence. He holds an office as
Why a person cannot have more than one position?
I'm not trying to say that, but I'm saying that he has an office and he's just serving on those
all of
committees.
them are all the offices of which he's in. He's in all those offices.
In the Ghanaian parliament, for instance, the standing committees of parliament, we don't regard them as working as office, like it's not an office for them, but they are there by virtue of that to be part of the, I mean, it's just to help the proceedings to run very fast as we want it to be.
I've heard
Do you
your
get that?
submission.
Good. And with regards to the exhibits that were tendered with Nisi and all that, my lord, if we are to we are to enforce that, that means Nisi didn't resign properly because no publication was made to the notice board. Nisi did not resign properly because no communication was given to the dean.
Yes, that's why when your counsel was speaking, I was making her know that, I mean, I was letting her mind the fact that it is not only one formality, it's not two, it's not three, it's four formalities.
But I've counted two formalities from their exhibits. That no publication was made, one. Nothing was given to the dean.
Yes.
Do you get it? And what they have to give to their respective heads is what I'm arguing of the fact that is to give them...
Yes.
Objection,
Please.
okay.
Yes, please. Okay, so as it pleases the court, right? The 14th SRC Parliament, okay, one of the members was His Excellency Kofi Boakye Apreku, as he was then the president for the Katanga Hall. By virtue of being the Katanga Hall president, he became the deputy speaker, right? Are you trying to say that since he was the deputy speaker...
The objection should be
yes,
a response to what he said, not a new
not
argument.
what you are saying.
Yes, please. I understand what you are saying.
I'm sorry, my lord.
Yes, so with the way you are, I think you're even making arguments for us because the procedural flaws that you are talking about, right, that you are saying Nisi's resignation was also not valid. That goes to say that then your client's resignation was also invalid. I don't know if you get what I'm trying to say.
I'm trying to also mean that
because if you
Nisi has been allowed to contest a position under JISA, which JISA is subjected to SRC constitution.
Is it our fault that an action was not instituted for that matter?
The speaker would have done that, just as he has done for
Because are you saying that two wrongs can make a right?
Yes.
Not please. I'm not trying to make that, but I'm trying to highlight the point that let's deal with the substantive of the matter. And I was taking, I was making reference to Black's Law Dictionary.
Don't have that view that we are not considering the substantive matter. We are just
no. I'm talking about the
technicalities.
Substantive
the
matter.
Formalities. None of them. Even if one of them was done, then we could have gotten a substance.
It was in writing.
To who?
The copy was made to the speaker.
The writing has to be to a particular person for that role to be, to have been satisfied. So you get it. So I'm trying to say that none of the procedures were followed. So there's no substance we can even draw from it.
So I'm trying to also make the argument that if he has resigned and he's no more the president, by what virtue should he resign as a parliamentarian? He is no more a president, and that extinguished him from representing us at the Parliamentary Council. So now, if he has to resign...
That's why I made that, I made an assertion that, I made an opinion that being a college president is just his ticket to enter. You get it? It's a ticket to enter. When he enters, he now has a new duty to do, which is to represent the people and people from course, and also to perform some SRC duties, right?
Yes, please.
Two of them. So if you cannot say that he holds two offices, and we should use the procedures from a college, we should disregard the provisions in the SRC constitution and use the provisions from the college constitution. It's actually a disrespect to the provisions of the SRC, the SRC constitution, that we shouldn't consider the methods, the rules espoused in the SRC constitution with respect to resignation, but rather we should consider the fact that because he satisfied the rules under the college. Meanwhile, there are two duties he's performing.
My lord, from Black's Law Dictionary, 11th edition, resignation is defined as the act of instance of surrendering or relinquishing an office, right or claim. Now, by virtue of what he has done, we've not had a president. If we should say that his resignation was not even valid, now he's not acting as our president again. He doesn't go for our meetings again. He doesn't represent us at the parliamentary again. So are we trying to mean that the people of course...
No, he doesn't, but it's like the Grassack president's case. He doesn't, but he's supposed to.
So should
yes, he can.
Should we say that he has resigned it's undisputed fact that he has resigned under college. So now, should we say that the resignation letter has not been submitted to the SRC speaker? Now he is a member of parliament.
It's an argument that can be raised on his behalf.
So I can be a member of parliament without being a college president. Is that what you are trying to mean?
That's what I'm saying, that he has entered. And once he enters on a ticket, he now assumes a different role, swearing an oath. Yes, but it's
one body. He entered with that body. And I had wanted to quote, he entered, it's not two distinct offices, as we are trying to claim to me.
Yeah, one is under the college. He still works as a college president in the sense that he has policies that he promised the College of Humanities and Social Science, and he's still undertaking those promises. Meanwhile, he's also working in the SRC parliament, passing bills. He's also performing functions of functions he's supposed to perform as a member of parliament.
I'm saying that he, by virtue of that, this is my last submission, then I yield the floor to my co-counsel to end our submissions. What we are establishing is that he has resigned. He's no more our president. I want this on record.
You're my professor.
So
you let me hear you.
He is no more our president. And he entered parliament just as we've agreed. So if he has entered something that granted you power to enter, and now we are trying to make it too distinct from two positions in that regard. So it's like a tree growing with a root. And we are now saying that now once the tree grows, we have the stem and the leaves. We don't have the root again. That's how we are trying to make the argument. He came with...
we are saying that being a college president, it's an
My Lord.
Being a college president, being the college president is the reason for which he entered. So that's why I keep asking that. It's not like we are putting aside a purposive interpretation or a substantive interpretation, but we are saying that, so why do you think that the framers of the Constitution would have 96(1) when they know that a person can...
96(1) has been boldly written, resignation. That is the substantive thing that the framers of the Constitution wants us to uphold. And now we've all come to understand the fact that resignation is a notice. Do you get that? And
yes,
now,
but in giving that notice, there are procedures to follow. In giving that notice.
So he has acted in good faith by resigning one, by giving a public notice to that effect. And now he has made a step to give it to the clerk. So if he had bad faith or had an extra intention that he wants to do the two things at the same time, why would he even proceed to send the letter to the clerk? And another thing is, the speaker in his audio has admitted to same. So if the speaker had no bad intention, I'm trying to allege bad intention, because the speaker has ordered the electoral commissioner to disqualify him in his letter,
because
paragraph 3.
Use that words against the speaker. Bad intention.
Yeah, and he even instructed him to leave the page. The page.
He instructed him to leave the page.
The page of, the WhatsApp group of parliamentarians.
He said he should leave the page.
He should leave the page.
My Lord.
By virtue of the fact that he has... please, I'm coming.
It's an objection.
My Lord, an objection to the analogy.
Objection on what he just said.
The analogy he made about planting a tree and at a point. My lord,
It's a matter of
he's
fact.
making his case based on
I'll give you the
knowledge.
opportunity
It's a
to
matter of
speak.
fact.
I'll give you the opportunity to make your submission after he does. So let him finish. If you don't have an objection
much
to an
respected.
immediate
Much
statement he
respected.
made, then you just...
Much respected.
The Constitution implies us to act with good intention. And now, that as it goes with the equity maxim, equity inputs an intention to fulfill an obligation. He has made all the efforts to do that. So if clearly there was even a breach as to the procedure, they should have at least...
It's not like breach up to the procedure. None of the procedures were even fulfilled.
Communication in writing, my lord.
To who? A publication in writing, where must it be done?
It has been...
So none of the procedures were followed. So we cannot even... It's like the thing was not even done itself. Or was not
No.
Do you understand what I mean?
No.
What I'm trying to say is that there are 4 procedures and none of them were fulfilled. So we cannot even say that we can take one of the procedures and draw substance out of it and extinguish the other procedures.
So, my lord,
but none of them.
So what's the communication in writing for?
The communication in writing must... This is how the Constitution
Good.
says.
So when we say communication...
Okay, sure. Yes, it must be posted on all notice boards. All notice boards within 4 days. 4 days after the receipt of the resignation letter.
Once a communication has been made, a communication is to put the respective authority in notice.
You don't think they have a reason, a substance, or there cannot be any purposive interpretation behind the fact that it must be posted on all notice boards
my lord,
and 4 days after receipt?
My lord, will agree with me for the fact that the custom, as it has been established, I've never in this life of my 4 years in KNUST seen that a parliamentarian has resigned and it has been published on notice boards. I'm not trying to base on that, but I'm trying to make the facts to the effect that now they are seeking to rely on that wrong to disqualify someone. Do you get that? Which is wrong, which is bad. They are...
They are even more than 4. Yes. So, not even 1. You get it? So, you can't say that they are just relying on...
So when we come to qualification for an office, I'm coming. With the leave of the court, let's go to Article 11. Article 11E. Article 11E. Qualification for candidates. Article 11E. We've established the fact that he has resigned, he has communicated to the parliament. So now, if he is saying that he shall not be an officer holding any position under the SRC at the time of filing his nomination forms, at the time of filing the nomination form, he wasn't a president. He wasn't a member of
You didn't
parliament.
see the position under the SRC?
So, at the time of, I'm trying to make emphasis on that. At the time of his nomination, the framers were very careful in the sense that they added at the time of his nomination to the effect that if you are filing a nomination and you hold an office, you can't do that. But by virtue of that, he wasn't holding a position. And I beg to differ in the sense that the Electoral Commissioner gave guidelines, rules that we are going to follow. We've done nominations. We've done verification of results. We've done a whole lot of things to vetting. Nomination that Electoral Commissioner should see and even disqualify him at the very point, even before he even appeared for display of aspirant. Nothing of that sort was done because the Electoral Commissioner deemed it right. Nothing of that sort was done. So if nothing of that sort has been done, why are we here challenging the fact that he has not resigned? And for the publication, it's not the duty of my client to even publish it. It's the duty of the council to do that.
Yes, but he didn't even receive it. So how does he?
So what's the clerk receive?
He has to. You know what must be published.
My lord, let's read what
what
was sent to the clerk. Let's read that. The public announcement. Let's read it. Let's read the public announcement. Please project the public announcement. Let's read it. The public announcement. Let's read it together. The public announcement. Let's read it together. Exhibit 3. Exhibit 3. Yes. So
Is he on it now?
and I want
Do we have a copy? No one has a hard copy for us.
it's there. The exhibit 3.
Okay, but I think I can see from it.
Yeah. So I want us to establish the fact that does the SRC Constitution recognize the court's constitution? Yes.
Yes, it does.
Good. Does the SRC Constitution regard our resignation as a right procedure to be followed?
Yes, under
Does
the college.
The
At college
SRC
level.
Constitution respects if that procedure is being followed?
Yes, at the college level.
Good. So if the person is elected as a president, when he gets to the parliament, by what virtue does he get to parliament? By virtue of he being a college president or a college general secretary. That has been established. Now, this is the communication. Dear students, publication announcement. The Judicial Committee of the College of Humanities and Social Sciences, Knust, hereby informs us the entire students body hereby inform the entire student body that it has formally accepted the resignation of His Excellency Nana Agyei-Gyebi from his position as a college president, effective July. That's what I see there.
No, help us with a better one, please.
Effective 14 July. The committee acknowledges. Good. The committee acknowledges with gratitude his dedicated service and has directed all outstanding duties and assets be duly handed over to facilitate a smooth transition. Duties mentioned here is his duty as a representative for us. So he has to hand all of them over. And
Council, but you see, I don't understand why we're referring to the public announcement.
If you should allow me to finish, you'll get to understand.
Yes, but I want to ask a question, then you can proceed. Okay. Are you saying that we should deem the public announcement letter as the resignation letter of your client?
Yes, please, because a copy has been made to the CC, the Speaker of Parliament, SRC. So the intention here is to...
But who is supposed to write the resignation letter?
My Lord, when I came in first year, I was the Deputy Judicial Chairperson for Independence Hall. When Abraham Roxen was resigning, we only communicated the resignation to the Speaker. And Abraham Roxen was allowed to file for his nominations, and he went on. The Speaker alerted us that when we even started to allow him to write to the Speaker formally, the Speaker was like, this is just a notice. So the resignation whole process is just to give the notice. And here, he has admitted to same in his audio. The Speaker has admitted that I recognize this, that he should leave this page. A clerk has received it, which is under the office of the Speaker, and he has to communicate to the Speaker. So if the clerk has not done what is expected of her, so even if, should the clerk have done the right thing, the Speaker would even have alerted him that, boss, do it this way for us. Do you get that? So the intention here was to do the right thing.
But it's also about the time, or you don't think the time?
The intention,
like when it was received. So even at the time it was received, if the speaker had suggested some corrections, do you think that corrections would have met the time schedule?
The clerk would have even communicated something, the opportunity to even communicate that the time has even elapsed. The clerk deemed it accepted. And if he has deemed it accepted, she cannot be, she's stopped from saying that such has not. So if the intention is to fulfill the obligation that I'm resigning, and I've done so, you as a clerk has to communicate to the speaker that someone is resigning. A copy has been given to you. A letter, a copy has been given to you. So the speaker would have even made a letter to the said copy that, please, so and so. But nothing of that sort was done. And I'm so afraid that this is going to set a bad precedent if we should allow the speaker to act on his own intention, even with the last paragraph that he said.
Act on his own intention.
Yeah, because in his letter, he said he is directing the Electoral Commissioner to disqualify. That means he has formed his decision already. Meanwhile, he is aware of the fact that a resignation letter has been given to him, and of the fact that a clerk...
No, Counsel, what you are doing is that you are trying to, make a judgment.
I'm not making a judgment.
No, relax. What I'm trying to say is that you are trying to make it look like, conclusively, the resignation letter, was actually written. You are trying to give a judgment. You are trying to do
my lord, I'm trying to help the court accept the fact that this...
No, but if you are going to say that the speaker was acting on a bad intention, it means that you are trying to say that he was the one behind, do you understand what I'm trying to say?
I'm talking in terms of the paragraph that he wrote. So if I'm here and I'm directing someone, which I have no power to do so, my lord, what is the intention?
No, did he say, but there's a petitioner, there's Francis Kusi.
Yes,
there's
a letter.
I think...
We can read the speaker's letter to that effect, the paragraph.
No,
we can all read that.
Where's the letter? Yes, let's read it.
Let's read the speaker's paragraph, the third paragraph. Speaker's letter.
Yes, but we need to start from the beginning. He says that in a response to a petition letter received at 6:35 a.m. on the 26th of July by a student seeking my attention and requesting for a copy resignation letter of Honorable Nana Agyei-Gyebi, the Member of Parliament for the College of Humanities and Social Science. The officer of the Speaker writes to confirm that Honorable Nana Agyei-Gyebi Dennis has not resigned to the office of the Speaker as a Member of Parliament, as the SRC Constitution states.
So the paragraph...
So I'm trying to say that he acted based on a petition that was brought to him.
So if you are acting based on the petition, you could have said you've not received any resignation letter. That would have been nice. But to come to your third paragraph and say, as a result...
But have you seen
what result?
No, have you seen the content of the petition that was sent to him? Yes, so if the petition that was sent to him spoke about, Agyei-Gyebi being disqualified, then of course he has to address it.
So, my lord, are we trying to say that now the Speaker of Parliament can direct the Electoral Commissioner to
No, but did he direct anyone? No one, it's his opinion.
No. As a result, the office of the Speaker directs.
So has Nana Agyei-Gyebi been disqualified?
That's what we are in court to challenge.
Yes, so I'm trying to say this is opinion. So you cannot say that the Speaker is the one.
So should we allow him to give a communication?
Who is following his direction?
My lord, I want to make emphasis to the fact that if by his audio he has committed sin, saying that I have received the thing, the person is saying I have received the thing. He didn't even question as to how it was supposed to be done.
He said he has received.
He has received the resignation. He recognized the resignation of Agyei-Gyebi and that he wishes to go. We can play the audio
yes,
again.
I'm very happy.
Sure. The audio. Exhibit 6. Exhibit 6.
Yes, once again, it's just my honest way of obtaining the truth.
Yes, please. Yes, please. Yes, please. Yes, please.
Yes, please, is he available? Yeah. You said? Oh, you said the guy is not around, but
Okay, so I want.
I don't understand what you're saying. When the person brings the resignation.
yeah, so the part at which you recognize that he has said what you want to hear, then you, so that, no, like I'm trying to say, identify that part, so that we can be playing it over again if we need to.
When the person brings the resignation, part of the process is that shows that the person has resigned is that the person is not on the page. And this, for that reason, I'm taking. I don't understand what you're saying. When the person brings the resignation, part of the process is that shows that the person has resigned is that the person is not on the page. And this, for that reason, I'm taking them off course. I realize that somebody wants me to be already system.
For that one, I'm taking him off. Who is he taking off? JB. Let's continue. Because he has resigned.
They were saying that. And for a long time, I wanted to, if not the SRC, I would have kept everybody on, but I just want to take them. After the house has been dissolved, we'll add them back.
Good.
They have to.
Pause. He even admitted that even there were wrongs. So he just sought to overlook that by his statement. Do you get that? So he is stopped from coming back to say that now go through the right procedure. Do you get what I mean? Please continue the audio.
Go, they have to go. I don't know why course will be denied. The General Secretary is there.
Stop. I don't know why course will be denied of a representative because the course General Secretary is there. That means the President's seat is vacant. Please continue.
His course will be denied fair representation. How is that true? The person has resigned.
The person
has resigned.
Pause. The person has resigned. The person has resigned. This is a speaker saying that the person has resigned.
Resigned from?
So the actual thing is, from his argument, so the thing is, he has admitted from the beginning of the audio that he is taking JB off the page. Which page? SRC parliamentary page. By virtue of the fact that he has what? Resigned. And now he's making emphasis to the effect that he has resigned. And I'm making emphasis of what he said, that he has resigned.
Your Lordships, respectfully, please, we had an if. Please, to the audio that was just played. We had an if the person had resigned. So if it could be replayed so that we all clarify what he heard.
Oh, come on.
It was like a conditional statement, like if the person had resigned. He didn't make it conclusive that he had resigned. So if he could play the audio again.
That's why I said you should identify. You see, that's why I was telling
So I was breaking it down so that we get to understand what he was saying.
So did you identify that part? Okay, you play it again.
So the thing is, he...
I don't understand what you're saying. When the person brings the resignation, part of the process is that shows that the person has resigned is that the person is not on the page. And just for that reason, I'm taking them off, because I realize that somebody
Please
wants
pause.
me to.
For that reason why I'm taking them off. So which if are you talking about? Please continue.
During these elections, and they were saying that. And for a long time, I wanted to, if not the SRC, I would have kept everybody on. But
If not for SRC, I would have critiqued. That means you know there is an error and you're admitting to same. Okay, if not for SRC, he would have kept the recording or even making that submission. Please.
I just want to take them after the house has been dissolved.
Please pause. If not for SRC, he would have kept them on the page. Thank you.
To add them back, but Charlie, they have to go. They have to go. I mean,
he has to go. He has to go. And he went. Please continue.
Know why course will be denied. So the general secretary is there.
Good. I don't know why course will be denied. That means the person would have raised course will be denied of a vacant seat. So he's saying that I don't know why course will be denied of a vacant seat because there is a general secretary to that effect. Please
course
continue.
Will be denied fair representation. How is that true?
How is that true?
The person has resigned.
The person has resigned.
Has resigned, and which of us is preventing courts from having fair representation? The person that is resigning and me that I'm accepting the person's resignation. Who's preventing the person from having fair representation?
So thank you. He said courts will not be precluded from having a representative. That means he's acknowledging the fact that the seat is vacant. Gyebi is no more. He's no longer in his house. He has resigned. Emphasis on he has resigned. Thank you. Please, I will yield the floor to my co-counsel. Okay, sure.
My lords, if you may please this court, we would like to draw your attention to something that the audio of the speaker, it was after that the petitioner petitioned him, and the petition is still valid. Clearly, the audio, the speaker wanted to cover up for him, but that was someone. Yes, but there was someone who wanted the law to take effect. So this...
I'm not getting your argument.
My lord, we are saying that, to begin with, the petitioner petitioned him after this audio, and it still makes...
But where are the dates? How do you prove that it was done after?
My lord, let's go to exhibits. Where's the petition? My lord, the audios were made on 25th. The audios were made on 22nd of July, and the petition was filed on 25th of July. Exhibit B. Exhibit B.
You are saying the petition was sent to him on 25th July, 2025?
Yes, please.
Uh-huh.
And the audio was sent to the Parliamentary Council group on 22nd. So we believe that on 22nd of July, 2025. So we believe that the speaker's attempt to cover up for Nana Agyei-Gyebi was seen by the concerned, or his attempt to cover up for Nana Agyei-Gyebi was intercepted by the petitioner's swift response to demand for a proof of his resignation, which the speaker failed to. So that audio, we believe it could be said that probably the speaker was covering up for him. Now, my lord, to...
Objection, my lord. Who alleges must prove, so he must prove that indeed he was covering up for Nana Agyei-Gyebi. Thank you. And if he was covering, why did he then later come to petition the EC to disqualify him? So he's ill-spirited, respectfully, my lord.
My lord, he entered through, my lord, we want to focus on the substantive matter at hand.
No,
but before we respond to
yes.
it, that is why I said we believe the speaker, the audio, there is a clear indication that if not for SRC, he would have commented on it. So it is reasonable enough to say that he was trying to cover up for him, that if he speaks or comments on it,
Objection,
it may affect the candidature. We can infer that from the very audio that was played to the court.
I didn't hear the last part because of...
So, my lord, if it may please the court.
No, I said I didn't hear what you were saying, the last part, because of
the audio, it said that he would have commented on it, if not SRC. And when we are talking about if not the SRC here, we could infer from the audio that he was trying to cover up for him, because as soon as he comments on it, it questions the validity of his candidature in the SRC race.
Objection, my lord. Please, from the audio, it is if not for SRC, I would have kept them on the page, not I would have commented. We can play again.
My lord, let's go back to the audio.
If not for SRC, I would have kept them on the page. Meaning, if not for SRC elections, they would have kept them on the page, because he actually stated that he doesn't want to lose the relationship he has built with all his parliamentarians. But if not for SRC elections, I would have kept them on the page, not comment.
My lord, may we have the audio?
Yes.
Opo, I don't understand what you're saying. When the person brings the resignation, part of the processes that shows that the person has resigned is that the person is not on the page. And just for that reason, I'm taking them off course. I realized that somebody once met me during these elections and they were saying that. And for a long time, I wanted to, if not the SRC, I would have kept everybody on, but I just want to take them after.
My lord,
after
can we hear that part again?
I would have kept everybody on, but if not the SRC, I would have kept everybody on, but I just want to take them after the house has been dissolved. We'll add them back by Charlie. They have to go.
If not for SRC, I would have kept everybody on. Most of them has resigned. Nisi has resigned. All of them has resigned. So he is saying that if not for SRC, he would have kept them on the page. So they should leave. They should leave. And they left.
If not for SRC, like how?
I mean, that one, I don't know. For the elections, he would have kept them on the page. That was what he said.
You said?
If not for the SRC, he would have kept them on the page. The SRC there, we don't know what he was actually to mean. But he is saying that had it not been the resignation, because he made a statement afterwards, that had it not been the resignation, do you get that? He would have maintained them on the page. You see, the speaker has established a cordial relationship with his members of parliament. So leaving them out of the page, they feel like, no, I should just keep them on the page because it's just a platform that we are all on and we are all having the social life. But he said, he was even helping them, that if not for the SRC election, he would have kept them. So he's leaving them so that they wouldn't even have issue with parliamentary council.
So, my lord, would that not be a cover-up enough for him?
Not cover-up. Go. You've resigned. Go.
My lord, I think since he said the SRC in the audio cannot be construed to be this or that, I think it was not conclusive. The audio was not conclusive in nature, but the letter or the petition, which he indicated that he has not received any resignation.
Objection, my lord. Objection. Please, Our basis was not on the SRC, whether it was election or was a page. Our basis for this video is the fact that he has resigned. He should leave. The fact that he would have kept them, but for the fact that they are going for SRC elections or SRC, what we don't know there, it's not factual here. It does not matter here. The fact that he has resigned, that is the reason why we played this audio. Respectfully submitted.
Yes. Do you have any submission to make?
Yes, my lord. The audio is even their evidence, so we want to focus on the substantive matter. So we want to also make it known to the courts that Nana Agyei-Gyebi entered through the tickets of course presidency, which we've admitted. But he entered into parliament on the ticket of course presidency, which we've admitted. But he could not have represented the people of course or perform the functions of the member of parliament of the SRC unless he had been sworn in and taken the oath of allegiance as seen in Article 46 of the SRC Constitution. By this act, he took the seat in parliament to perform his functions in parliament. This is a practice in the SRC parliament. Admittedly, he complied with it. Hence, his entry into parliament was valid. But the bone of contention now is how he exited from parliament. So, my lord, the same way an individual or the same ladder an individual used in climbing to the top of a building should be the same way he would descend when. So they believe that the procedure or the constitutional procedure which was followed to make him a member of parliament is right. But they don't believe that it would be right and prudent for him to also follow the same constitutional procedure to exit from parliament. So, my lord, claiming to mere procedural requirements, the procedural requirements provided in the Constitution cannot be waived off by the courts, as established in the case of Daloma versus Pupulampu. He cannot, the procedural requirement provided in this Constitution cannot be waived off. Then again, so per precedent, Nisi Agyei, Kelvin, Michael, Kekeli Willingham, who sent their resignation to the speaker, and Agyei-Gyebi did not, cannot evade this set convention or customary practice. Then, my lord, the law is clear per section 96 that any officer, SRC parliamentarian, is an officer, as it has been said here, shall communicate his resignation in writing to the respective head, in this case, the speaker. The law requires that the officer himself, not an agent or through a third party. This is a mandatory provision, and meaning should not be read in it to be construed otherwise. If this mandatory provision has not been complied with, there is a clear breach of the Constitution. Then again, even in paragraph 8 of their statement of defense, there was a concession that the Dean of Students was not copied the resignation through a characterized, it was characterized that as procedural. It is not mere technicalities, but a substantive breach of the Constitution. The first requirement, an address to the speaker. It did not say a copy to the speaker. And even in their said letter of resignation, it was a copy to the speaker and not an address to the speaker. The first requirement was not met. The second requirement was also not met. And the third requirement as well. They have admitted that the Dean of Students did not receive a copy. And we believe that the omission not to properly notify all relevant authority, particularly the head of the council, the speaker, and then the Dean of Students, undermines the validity of his resignation and leaves a status that the first respondent or the respondent is an SRC officer unresolved at the time of nomination. The Constitution requirement is not satisfied by partial or informal step. It demands full compliance with a prescribed process to ensure transparency and institutional accountability.
Objection. My lords, if my learned brother on the other side made mention to the case of Dalumau versus Palampu, it would have stated that inasmuch as statutory requirements cannot be waived, the court stated 4 instances where the statutory requirements can be waived, and one of them, including a mere procedural defect, it can be waived. Accordingly.
A mere. Mere. But, Counsel, I want you to...
One of them including that it is merely...
My lord, with the points she's making to object what I was saying, the Constitution is not a mere statute.
Objection. But we are talking about Constitution. You've mentioned a case that's talked about a statute. So what reference are you making?
Arguments from both sides will not hold.
Thank you.
My lords, we address this court not with mere legal arguments, but with a plea grounded in justice, humanity, fairness. My lords, my client is not just a candidate on the ballot. He is a student, a servant leader. He has poured out himself, heart, mind, and soul into the race. My lords, he has walked the length and breadth of campus.
But which part of your submission is this?
He has walked the length and breadth of campus, from hall to hall, room to room. My lords, sometimes they stand in the rain and even in the sun to contest, to campaign. My lords, they have printed banners expensively. They have printed billboards, my lords, drafted policies, and even inspired others to believe that the SRC can become something again. And my lords, now all this is at risk, not because our client has violated the Constitution, not because he has held on to power unlawfully, not because of CWA, not because he has sought unfair advantage, but because someone claims there was a misstep or that he forgot to copy a recipient. My lords, even the dean works with the provost. My lords, this is the entire basis. It is a technicality. My lords, a curable one, harmless, and indeed a non-substantial technicality. My lords, even if there was a procedural misstep, which we do not concede, my lords, it is a kind of misstep that can be remedied without injustice to anyone. My lords, it is a kind of misstep which can be remedied without injustice to anybody, my lords. It goes not to the root of the eligibility of our candidates, my lords. It does not affect the eligibility of our candidates, my lords. It is a mere error. It has caused no confusion, my lords. It has caused no deception, no institutional harm. It is an error, and my lords, it is an error of form, not of substance. It is an error of form, not of substance. My lords, can we in good conscience equate a missed copy or a document title with the erasure of months of sacrifice? Can we in good conscience, my lords? Does that weigh evenly on the scales of justice? My lords, it is evident that the Constitution was not made to destroy destinies over curable missteps. It is evidence that the Constitution was not made to destroy destinies over curable missteps. It was made to uphold fairness, transparency, and participation. And my lords, this is all we are asking for, fairness, my lords. We respectfully pray this humble court that he dismisses the petition. But if this committee in its own wisdom thinks that a procedural step was missed, we kindly ask that the respondents be given the opportunity to remedy it, be given the opportunity to cure it, because justice demands no less. Respectfully submitted.
My lord, equity can't be an excuse when the law is express. And there is a maxim of equity that equity favors the vigilant and then not the indolent, which is a clear admission that there was a procedural mistake, and in this case, it's a matter of constitution. And it's a matter of constitution, and it cannot be brushed off under the umbrella of equity. My lords, we respectfully submit that.
Objection, my lord.
We respectfully submit that allowing a person who has not duly resigned from the current position under the...
Yes.
My lords, do we still think he has not duly resigned after the audio, after all the exhibits, and you still stand,
lord,
and the fact that he cannot even go to parliament and represent, you still submit that he didn't resign? Oh,
My Lord.
Equity follows the law.
My Lord, I think on his resignation, it's up to the court to resign. And it is onto the court to decide. And even in paragraph 8 of their statement of defense, there is a clear admission that the procedure was not duly followed, throwing light on the fact that the dean never received a copy. Then also, it was not addressed to the Speaker of Parliament. My Lord, if they are coming under the umbrella of equity, there are quite a number of aspirants whose CWA, which is a requirement to run this race, was changed as a result of their efforts, as a result of fighting to lead.
Objection. We are not disputing CWA here, my lords.
If they are coming under the umbrella of equity, then equity should favor those people. But my Lord, we are still saying that and submitting that allowing such a person who has not duly resigned from the current position to contest for another would set a troubling precedent. One that strikes at the heart of the electoral fairness, discipline in leadership, transition, and in the integrity of our representative institution. In the nature of precedent, such as a decision that would far-reach consequence beyond the present matter, it would open doors for individuals to hedge their political ambition by holding on their current office as a form of political insurance while simultaneously seeking election for a different post. This practice will encourage a culture of opportunism rather than a genuine leadership and accountability. Future contestants, observing that the resignation is no longer a prerequisite to contest for another position, may begin to exploit this loophole. They could retain their current position, confinement that the event that they are unsuccessful with the new election, they can conventionally fall back on the position they never formally relinquished. The dual benefit is contrary to the principle of fairness and commitment to service and must govern all election. My lords, such an outcome would defeat the principle that one must vacate a position before seeking another, an expectation grounded in both ethical responsibility and administrative clarity. It ensures that the electoral process is not manipulated by unwilling to risk their current authority. It preserves the integrity of succession planning within the student and public institution. So we humbly pray that this court declares the first respondent's nomination null and void for failing to comply with a constitutional requirement to resign from an office prior to filing of nomination, and also at large affects the entire presidential ticket on reason that it is a joint ticket and not a single ticket, based on the fact that on display of aspirants on the ballot screen, it is not always the case that they have the two candidates there, but a single candidate they humbly submitted, my lord.
Objection, my lord.
Yes, what's the objection?
My lord, counsel argued, in his statement of claim, actually admitted that we have resigned. It's just that we didn't follow due process. Okay, my lord, we have already admitted that it is a procedural error. But my lord, is public policy not a principle again? Public policy says that in the interest of others, or in the interest of justice, other things should be taken into consideration. My lords, I've already espoused the length and breadth our client has done and all the expenses our client has used in trying to pursue this vision. My lords, should our client's eligibility be struck out on this basis? My lords, he has already established that there was a resignation. That he's not in dispute, but he's in dispute of a procedural error. My lords, again,
you agree there's a procedural error? Is that what you're saying?
Yes, obviously. That is what.
No, I didn't ask you.
Sorry, my lord.
I'm asking her. Please, let me ask. Let her answer. She's the one talking, so let me get an answer from her. Do you agree there's a procedural error? But what have you been saying so far? You said even though there's a procedural error.
No. My lords, we are not admitting that there was a procedural error.
But that's what you just said.
We are saying that in the
you are giving an in any case argument, and you are saying that in any case there's a procedural error.
My lords, may I retract my
You are retracting.
Yes, please.
But how, if you don't believe there's a procedural error, how do you say that there's a procedural error?
My Lord, sorry. Please, we are trying to say that if in your own wisdom, if in the wisdom of this court, there has been a procedural error, then it can be remedied because it is not harmless. That is what we are pleading the court. So we've not accepted that there was a procedural error. But if in the wisdom of this honorable court, there is a procedural error, then it should not be fatal enough to disqualify Agyei-Gyebi and even disqualify Mr. Bernard Bosomayeboa. Respectfully submitted.
My Lord, in response to the objection on public policy, coming under the arguments that is public policy not applicable here again, I believe public policy would have been applicable where the law is silent on that. And now, my Lord, on the very matter we are arguing on, the law is very clear on that, and I believe that the law must prevail over public policy and even equity. Humbly submitted.
Objection,
my Lord. Please,
wait.
Please let us finish if we can.
Okay.
Please, if it pleases the court, right? From their substantive defense, statements of defense, paragraph 8. I'm reading it out. Yeah, no, but she said they don't admit that there was a, but over here it says, while it is conceded that the Dean of Students was not copied on the resignation, this omission is procedural, not substantive, meaning that you people, you're of the opinion that there was an error there. So why did you now answer the court and say there was no procedural error? So which is right? Should we take what you are saying or what you have written? Which one is correct?
Yes, okay, please. My Lord. So with the objection of the public policy, if we look at the election petitions in 2012 and 2016, the court headed by Chachuti Kata in 2012 stated that even though there has been some violations that could have made us rerun the elections, but based on public policy, we cannot rerun the.
In the context of public policy,
yes.
You should realize that an election was organized already.
No, he is saying that public policy does not. This is an electoral process. So every step counts.
Yes, you are saying that public policy should be considered, and that you're also relying on the election petition case. And I'm saying that the election petition case is a case that occurred after an election has been organized. So because if an election has been organized, and you are now going to say that the person who won did not win, is going to, of course, bring a lot of chaos in the.
Respectfully, this is also.
But in this case, the election has not been organized.
My Lord.
Already. So if you are making the, I'm trying to understand your public policy argument. I'm done. I'm done speaking.
You are done speaking.
Oh, you didn't hear what I said. I'm saying that the case you are referring to is a case that, the decision was given based on an election that has been organized. And I'm saying, of course, if an election has been organized, a winner has been declared, and later they come say that the winner is not, the person who won is not a winner. It's going to bring a lot of chaos.
I get to my Lord.
And so that's when the public policy arguments work. But in this case, the election has not been organized already. It has not been organized.
But my Lord, respectfully.
So how does the public policy arguments work over it? My
Lord, respectfully, we relied on the case based on public policy, not for the fact that elections has already been held.
Yes,
but then if I should ask, should we wait for the elections to be held first before we bring public policy? Or should we wait for Mr. Agyei-Gyebi together with Mr. BBY be disqualified before we bring public policy? I think it is just reasonable to chip it inside.
I don't understand you. You are saying that.
Okay, so we are of the view that in the 2012 and 2016 election petitions, the judge was of the view that, the judge of the highest court of this land was of the view that for public policy, even though there has been some electoral violations, for public policy, we should not rerun. I'm not trying to put it in the same shoe, my Lord, because from other cases that we've said, automatically some of the facts are entirely different from the facts in front of us right now. But then we are trying to say that public policy can work here because taking into consideration all the contestants or all the candidates, their time, their effort, their everything, and even the student populace, then we can chip public policy in it. Sorry, my Lord. even to the point of vetting, manifesto reading. Yes, please.
Lord, I would want to leave the court with this submission. This would be my last submission to that effect. And I would want to quote something from the Holy Bible. And it is from 2 Corinthians chapter 13, verse 8. It states that, "For we cannot do nothing against the truth, but for the truth." The truth here has been established in an audio to the effect that the speaker has admitted and recognized a resignation letter from Nana Agyei-Gyebi. So I leave the court with this quote, respectfully submitted.
But I want to ask one question. For the basis of obtaining the truth and helping the case, so I want to ask, don't you think, it's a question I'll ask you, don't you think that, for example, counsel for the petitioner was making the point that the speaker, there are two different dates. A date was made, the audio was made on a date earlier before the petition was brought to the speaker and for which he responded to it. So don't you think that maybe he had an opinion before the petition was brought, and when the petition was brought to him, he later realized that there were constitutional breaches. That's why there was a sudden change in mind. Because the petition was brought to him after he made that audio. So yes, I'm sure that you help your case if you can prove that even after the petition, the speaker was of the view that he has resigned.
So there is lapse of time from the day he recorded the audio to the day the petition was filed. So if the speaker had a reservations to make a change, he would have even make a step even before the petition was even filed.
I'm not getting you.
I'm saying that there was lapse of time between the recording and the petition. So if the speaker, through his own intention, saw the constitutional irregularities and that he had wanted to enforce him with good intention.
It could be that maybe he was not aware of the constitutional irregularities, and that.
My lord,
I'm coming. Let me make a point. Yes, it could be that maybe he was not. It could be not that it is. Yeah. It could be that he was not aware of the constitutional irregularities. But when a petition was brought, to him, then he realized that there are four rules that must be followed. And that's why maybe in his petition, he started by saying that in a response to a petition letter, to a petition letter received at 6:35 a.m. on the 26th of July by a student seeking attention and requesting for a copy resignation letter of Honorable Nanaji. And this was done after the audio.
Okay, so thank you, my lord. The issue here is, if, so far as I'm privileged to what the speaker has, he has a legal aid. He has a legal aid to that effect. So if, and we cannot disregard the high office of the speaker. In this case, a house that makes our laws. And now we are trying to make the argument for the speaker that he is ignorant of what the law says. And now he, by then, was not knowing the law. And subsequently, it was when the thing was triggered. That's when he got to understand that there is a law in place and he has to admit to same. And even if he had acted on a good faith, he would have made a submission to the effect that the right procedure has not been followed. He had the authority to do that, but he waited. So had it not been the petition that was triggered, that means the procedure would have been followed. Do you get that?
What I'm trying to say is that it could be that you are... Can you hear me? Yes, it could be that before he was not really aware of the constitutional irregularities. Yes, and later on, he realized, someone brought it to his attention. You get it? So if on the notion that there was no irregularity, he said, even from the audio, it can be implied, like what the petitioner was saying, it could be implied that he didn't want any future allegation to be raised against Nana Agyei-Gyebi. In the sense, that's my opinion. I mean, that's the inference I'm making from it, that he didn't want anyone to come and raise a future, an allegation against Nana Agyei-Gyebi in the future. So that's why he said, if that is the case, because he's going for an SRC position, let us just remove him from the position so that nobody can come in the future and say that he was part. Yes. Because if today he was part of that group, then it could be a reason, it could be an argument that he's still a member of parliament, if he was still in the group. So that's what I'm trying to say, that maybe the speaker was trying to help him based on the fact that, based on the notion that he had done the right thing. But later, someone brought a petition to him and he realized that, no, the right thing has not been done. And that's why there's a complete change of mind.
My Lord.
No, that's a question.
No, I'm speaking to you.
Yes, so, my Lord, all you are saying is could be, maybe, that is assumptions, which is very much rebuttable and has been rebutted with the audio. He has resigned.
So you are saying that you can rebut. Yes, so you are saying that, not that you should play the audio. No, so you are saying that you can prove that at the time that he made that audio, he knew that Nana Agyei-Gyebi had not done the right thing.
We can prove with what he said, he has resigned. My Lord.
Yes, because what I'm trying to say is that can you prove that he knew that Nana Agyei-Gyebi has not done the right thing according to Article 96.1, but still said that, because if you are saying it's rebuttable, then it means that is what you should be proving, that he knew.
So, my Lord, ignorance of the law is no excuse. So if he didn't know, and I'm of the opinion that he should have known that maybe there was a procedure.
Now he knows, and that is why they have brought the petition.
My Lord, apparently in his petition, he said he has not received, not even procedural impropriety, he has not received. My Lord, do you get what you are trying to say? In the recording, it is, I have received that he has, in the recording, it is, he has resigned. Now in his petition, he has not received. He didn't say that there was procedural impropriety in his petition. So, my Lord, we should not infer procedural impropriety here.
That's why there's an argument that maybe he said, he actually said he has resigned. Yes. Sorry. He actually said he has resigned, right? Yes. But he didn't say, maybe the speaker thought that maybe based on the fact that he has resigned from course, he should be removed. But later someone let me finish. Yes, but later someone brought a petition to the effect that, no, there is a process that must be done with respect to removing the person from parliament. Resigning from parliament. You get it?
Yes, my Lord. So now even the Speaker of Parliament, the highest authority in Parliament, thinks that resigning from course means that you are no more a parliamentarian. So, my Lord, just give us that mercy that we also thought that resigning as a course president means that we are not even admitting that.
And later he has realized that it is not, so you should also later
that is why we are imploring the court to let us amend it.
We should amend the constitutional provision.
Exactly.
We can do that.
That is, no, not the constitution. Amend the procedural impropriety, because even if the highest...
I don't understand. We should amend...
We should allow him to see the remedy. We are talking about remedy here. Because you are of the view that the speaker was at fault for not knowing that procedurally he has complied with all the steps. And that is where the petition triggers his knowledge to that. Now the petition triggers all of us our knowledge. So that is why we are imploring the court that even if in your own wisdom you think that there has been procedural impropriety, this can be remedied. A very harmless thing that has been caused. It means that it can be remedied. My Lord, that is why we are imploring the court. No right has been...
My Lord.
By ceasing the Dean of Students. No, we are not. No, the court cannot. But the court can make a declaration that he should cease because no right has been breached, no right has been violated whatsoever.
My Lord, for me to humbly,
Okay, so how do you remedy a wrong if you've not admitted to the fact that you've committed a procedural wrong?
Please, my lord, my lady, we are not admitting, but even if in the court's wisdom we have committed procedural impropriety, then we are imploring the court to help to make a declaration for us to remedy
it if you have not admitted, if there is no error?
The court is the highest authority, so if the court, in his wisdom, again, thinks that there has been procedural impropriety, we are saying it shouldn't be fatal enough to disqualify them.
But do you think the court has a reasonable grounds to believe that there are procedural improprieties?
My lord, we are saying that in your own wisdom, so this is a thing we are leaving to the court. If the court thinks...
Doesn't mean that...
Objection, my lord.
I'm coming. Are you saying that our reason, even if our reason is not, it's not reasonable to you, in case we end up... No, but that's what you are trying to say.
No, you are the highest authority in this room right now. What you say prevails.
But my question is that the assertion that you are making, or the kind of plea that you are making, it means that you yourself, to an extent, let's say, not maybe 100%, but let's say 70, no, not 70, but maybe 30%, you believe that there have been some procedural improprieties, and that is why you are raising that kind of in any case argument. Because that's what you don't understand what I'm trying. Yeah, I'm trying to say that if for example, if you have a client, or let's say you are even defending yourself, that someone has raised an allegation against you that you have killed someone, right? And you believe that you have not killed the person. There's no way you come and say, in any case, if the court says that I killed the person.
My lord, this analogy you are making is a criminal case, which we have to establish mens rea.
You have breached the contract. So what should I should breach? That's why you have breached the contract. So is it because it's criminal? Should use a civil case instance? Okay, so tort is a civil law. So battery, you have committed battery, right? Someone has has accused you of committing battery, right? And you are telling the court that even if the court believes that I actually did it, the court should have mercy on me. That's what you are trying to say, that the court should have mercy.
Yes, please, the court is a court of equity, because the analogies
And
you are
I'm saying
making
that
is far-fetched,
if you really believe that you have not beaten the person.
But then our minds are not the minds of this honorable court. So we are saying if we are not, in fact, our reliefs, the first of it all is that this petition should be dismissed. That is our first relief. It should be dismissed. That is our first relief.
Okay.
Yes, and our second relief is now conditional. Even if there has been procedural impropriety that the court thinks has happened, then equity should kindly come inside to remedy this harmless cause.
In paragraph 8 of your written statement, it seems you admitted to the fact that you committed a procedural wrong.
My lord, it is like we are not adhering this court to the fact that we said that substantially he has resigned. My lord, please.
So you are of the view that no procedural error has been committed?
In our statement of defense, our only procedural error that we...
So are you admitting to the fact that a procedural error has been committed?
Not everything like the opponent says.
Not everything, but some procedural errors have been omitted.
Just that we didn't CC the dean.
So are you admitting to the fact that a procedural error has been committed?
Yes, please. a procedural error, not procedural improprieties.
Okay.
My lord, can they help us read the difference between the procedural error and not procedural impropriety? Can they help us?
Oh, my dear, it is just singular and plural form that I'm using. I mean, procedural improprieties one, procedural improprieties plural. Exactly, and which can be remedied very.
But was it published on a notice board? Okay, which was the one? Which is the one you are talking
Please,
about?
the publishing is not the duty of the court president.
No,
it's not the
okay,
duty of
relax.
our client.
You said just one was. No, what did you
Which
say?
we are admitting
You
our
said
defense.
just one was okay. So which is the one? Please repeat it so that.
The fact that we did the JC didn't CC the Dean of Student of Affairs,
Okay.
which is even the Directorate of Student Affairs as we speak.
Okay, but if it is only one, that's what I'm asking. I'm trying to ask you that. You are saying it is only one. And I'm trying to ask you that, was it published on a notice board? Or it's not part? You think it's not part?
My lord, they came under 96.1. And the publishing is 96.2.
When I made that submission, you agreed with me
Yes,
that we are supposed to
and my lord,
combine
it
all
is
the
supposed to be the
provisions.
duty of the council, head of council, which is now the Speaker of Parliament, to publish it, and not the duty of my client. My client don't even have a letterhead as we speak.
But he said he didn't receive it.
And that is where the lie comes in, the audio. That has stopped him from the fact that he had actual and imputed knowledge that he has resigned. My lord, please. He had actual and imputed knowledge that he has resigned. So if my speaker comes back and says that he had actual and imputed knowledge because he admitted, oh, he has resigned. Both of them, actual is enough. Because from his conduct, he has actual knowledge of the fact that he has resigned. So now if my speaker comes back in a petition to write that he doesn't know of it, then it is nothing but a political motive. And we are imploring this court to not use its highest authority as a tool to influence political motives, my lord. Respectfully submitted, my lord. Thank you.
No submissions from you. Last one.
My lord, since my learned senior colleague decided to resort to the Bible before his submission, I would also like to quote a Bible scripture from Proverbs chapter 18, verse 17. It says, "The one who states his case first seems right until the other comes and is examined." My lord, throughout their submission, my lord, still emphasizing on paragraph 8 of their written statements of defense, it has been clearly accepted that the dean was not copied. They have accepted that in court, and they are now coming under a plea of public policy. But in the case of Egerton versus Brownlow, the court said that public policy is a very unruly horse. And once you get astride, it's to you. You never know where it will carry you to. My lord, there is a clear provision, and there is a clear provision in the Constitution which should not be overlooked. I'm surprised my learned colleagues here are even causing us to go back and forth with this, when the Constitution is so express that the letter should be addressed to the Speaker, not even copied to the Speaker, addressed to the Speaker on the resignation, and same should be copied to the Dean of Students. And there is a clear exhibit before this honorable court saying that the Speaker in a petition to the Directorate of Students that the said member of Parliament has not resigned. My lord, coming under the plea of public policy, we do not think it is best when the Constitution has spoken, because this is not the first time this is happening. In the year 2008, same happened to ABC, who was a presidential candidate. So, my lord, he's not the first, and he's not going to be the last two. So, my lords, we are still praying that this honorable court of competent jurisdiction would declare the first respondent's nomination null and void, and to the large extent affects the entire presidential ticket on our joint, on the joint ticket principle. Humbly submitted, my lord.
Thank you. We'll go for a break. Yes, we have to go for a break. I'm not the only one making the decision. We are Judicial Council. Thank you. So we'll go for a break. 10 to 15 minutes time, we'll be back.
Thank you.
All right. Thank you very much for your patience. We would release the final, this is a ruling, we'll release the final judgment later on. Upon a careful consideration of the facts and arguments presented, it is the firm resolve and final decision of this court that the relevant question for determination is whether the provisions of Article 96 of the SRC Constitution, when given a literal interpretation, will lead to absurdity or not. The question arises because the court has been invited to determine whether, one, a member of parliament who serves in that capacity by virtue of being a college president and subsequently resigns from his position as president continues to represent his college in parliament. The second absurdity is that if the president resigns from the college or is removed from office, can he still be considered a member of the SRC parliament even though he no longer holds the representative mandate of his college? These scenarios, if upheld under a strict and literal interpretation, would undoubtedly lead to absurd conclusions. For instance, maintaining that a person who has been ceased to be a college president continues to sit in parliament even though he no longer represents the people of that college contradicts both logic and the principles of representative democracy. The Supreme Court of Ghana in Agyei-Gyebi versus the Attorney General and Akwete, 2005 to 2006, Supreme Court Ghana Law Report 732, held that a purposive approach to a constitutional interpretation is warranted where a literal or a strict interpretation would lead to absurdity or defeat the intention of the framers of the Constitution. Applying that principle, an interpretation that the respondent, having resigned from his position as a college president, nevertheless remains a member of parliament under the SRC Constitution, would clearly result in an absurd situation. It would mean that the respondent, that is Nana Agyei-Gyebi, retains legislative authority and responsibilities on behalf of a college he no longer leads. And this is surely an untenable proposition. Therefore, the court is unable to enforce an interpretation that results in such absurdity. What happens to the provisions of Article 96 of the SRC Constitution? The provisions of Article 96 of the SRC Constitution should apply or shall apply to the SRC officers such as the marshal, the clerks, and the members of the UNLC, whose tenure and resignation are governed solely by the SRC Constitution. These officers do not operate under any independent or subsidiary constitutional framework. Thus, their resignation must conform to the procedures outlined in the SRC Constitution. However, a different legal position applies to the officers such as the ISA president, executive council members, the Obuasi presidents, as well as college presidents and secretaries. These individuals derive their authority and occupy their offices under separate constitutional regimes specific to their respective colleges or campuses. Consequently, a valid resignation under their respective constitutions fully extinguishes their office and representative mandates, including any associated seats in the SRC Parliament. There is no requirement for an additional resignation process. In essence, while Article 96 applies strictly to the SRC officers without independent constitutions, those who serve under distinct constitutional orders, such as the ISA, Obuasi, and the colleges, vacate both their executive and parliamentary roles upon resignation from their primary office without the need for further invocation of Article 96. Accordingly, I hereby declare that the petitioner validly resigned by virtue of his resignation at the college level. Which accordingly, can we have some quiet so that accordingly, I hereby declare that the petitioner validly resigned by virtue of his resignation at the college level, which effectively extinguished his mandate and representation in the SRC Parliament. Thank you.